Recording in
element
progress.
of hate speech. So again, here we submit that where the prosecution declines a charge of hate speech, there should be an express legal obligation on the Director of Public Prosecutions or their delegate to provide a complainant or the associates with written reasons within 3 working days. Again, here also the same reasons also apply. Also, defining the working days as any other day than a Saturday, Sunday, or a public holiday. So also similar to section 3, we wish to that there be a legal duty on the part of prosecution to provide written reasons for declining within 3 working days, also to ensure speedy resolution. And then here we come to section 5. We are definitely encouraged by the provision that requires victims' authorization when a person other than the victim is making a victim impact statement. However, we wish to point out that the nature of hate crimes in South Africa at times regularly leads to the death of the victim. In other words, a victim may not be able to either make a victim impact statement themselves or indeed authorize anyone else to do so on their behalf. So because we know that hate crimes are message crimes, and while they may be an individual victim of the crime, the impact is also felt by the community and groups to which they belong. So here, for this reason, we submit that a prosecutor should be empowered by the bill to obtain expert input on the victim impact statements from interest groups and organizations who work directly with the community or group to which the victims belong. We believe that this will greatly help courts understand the impact of hate crime, not only on individual victims and the associate, but the broader group and community to which the victim belongs, especially if the hate crime has caused a victim's death. So here again, we also wish to create a mechanism where, in the event where the victim has died, we have a mechanism where their voices can still be heard. So we believe that this is appropriate and necessary, given that hate crimes are message crimes spread through fear and affect equality and dignity of entire populations of communities and groups of people. So with this regard, we would like to submit that section 1 should be reworded as follows. So for the purposes of this section, a victim impact statement means a sworn statement or affirmation by one or more of the following persons. 1, the victim. 2, someone authorized by the victim to make such a statement on behalf of the victim. 3, in the event, so this is what we propose. In the event of the victim's death, the victim's associates, 4, an organization or institution with expert knowledge or experience of the group to which the victim belongs or is perceived to belong, which contains the physical, psychological, social, economic, or any other consequences of the offense for the victim and the associate. So here again, inclusion of who can make also the victim impact statement. So we would like also to open it to organizations, institutions with expert knowledge or experience. So in the case of an LGBTI person, an organization that works with LGBTI people can be of assistance to courts. I just want to check with colleagues. Are you able to see my PowerPoint?
Well, from my side, I can see it, but it's not moving. But I've also been having a bit of network challenges. So from my side, I'm not sure. Honourable members, you're having the same challenges I am.
No, it's just been stuck on section 5 all the time.
5, yeah, it has. Yeah.
Is it section? Are you all on section 5?
All of us are on section 5.
Okay.
We've not moved
from section 5.
Okay, so
right
I think
from the
I
beginning.
think we're still good. I thought you were not see, you know, because if you see section 5, that means you can see we are moving. Okay.
No, Katlego, you're not understanding. Since the beginning of your talk, it has been on one page, so it has not moved at all. So we have not been able to follow along with what you are saying.
Okay, it's fine. Ma'am, let me deal with this. Thank you very much, Ms. Lithgow. Yeah, yes, I know that I didn't raise it because I've been having a bit of network issues, so I thought it was stuck on my side. But be that as it may, you may continue from where you are. I'm not sure why your slides, your screen's not moving, but we do also have your written submission with us. So please continue, ma'am.
Okay. So yes, to include organizations and institutions. So yeah. So we also looked into section 5.2. We are encouraged that the bill creates an obligation on prosecutors to provide written reasons to the court in the absence of a victim impact statement from the victim. However, we are concerned, as noted with the previous section, that is only limited to that of a victim. So again, we are concerned in a situation where the victim has passed on, is dead. Include also organizations and institutions with expert knowledge or experience to also be included with the purposes also of the victim impact statement. So in this regard, we submit that the VIS must also extend to, in the event of the victim's death, the victim's associates, an organization or institution with expert knowledge or experience of the group to which the victim belongs or is perceived to belong. Further, in this regard, we also propose the following subsection 5, subsection 3, which can be added as follows. Where it is not possible to obtain a victim impact statement provided in subsection 1, the prosecutor must provide the court with written reason for the absence of such a statement by either the victim, the associate, and this is what we propose, or an organization or institution with expert knowledge or experience of the group to which the victim belongs or is perceived to belong. And then we'll go to subsection 8, which speaks to the reporting on the implementation of the Act. We support the provisions of section 8. However, we submit, due to the public interest nature of hate crimes and hate speech in South Africa, section 8, subsection 2 must be equally extended to the public. Therefore, the information contemplated by section 8, subsection 1 must be available to the South African public. In this regard, we submit the following inclusion must be made with regards to that provision. The provision reads that the information contemplated in subsection 1 must be made available in the prescribed manner and at the prescribed times to Parliament, the chairperson of the South African Human Rights Commission, C, the chairperson of the Commission for Gender Equality, and the chairperson of the Commission for the Promotion and Protection of the Rights, Cultural and Religious, so CRL Commission. We would like to propose the 5th one, which will be public, the South African public. We believe that, you know, it is in the interest of the South African public that also the reporting happens publicly, and people also are kept abreast in terms of trends, the trends around hate crimes and hate speech is purported by the bill. And lastly, we'd like to talk to refer to section 9. We support the provisions of section 9. However, we would like to suggest that adequate funding is allocated to strengthen the work of the awareness campaigns and trainings of officials. Would also implore that experts in sexual orientation, gender identity, and sex characteristics should be consulted, alongside with civil society organizations with experience in these areas. And also this will include, other sort of interested groups, refugees, migrants, asylum seekers, etc. So yes, so this also brings us to also the costing of a bill, which we believe would be great for greater accountability. We note that while various versions of the bill have been available since 2006, the bill remains uncosted. We note with concern the general poor implementation that generally plagues many South African laws. We would like to just admit that we are deeply concerned that the lack of costings means that the bill may suffer also the same fate. Thank you very much.
Thank you very much, Ms. Sipho Tekele, for that presentation. Honourable members, are there any questions? Are there any questions for clarity?
I'm more than happy to share. Sorry?
Honourable Badenhorst, if you could ask your question.
Thank you, Chair. Thank you very much. Thank you for the opportunity. I note that Ms. Sipho Tekele, that your grouping says that it supports the stated objects of the bill. I would just like to ask you, one of the main objects of this bill is to criminalize hate speech. But in the definitions of this bill, it only indicates a definition for harm, and it doesn't indicate any definition for hate or hatred. What is your take on that? Have you got any viewpoint, or whether that makes this bill a legitimate bill or not? I appreciate your input. Thank you very much.
Sure, I think it does make it a legitimate bill.
Thank you very much, Honourable Badenhorst.
If I could,
Ms. Sipho Tekele.
If I understood your question correctly, I think that the bill is relevant in the South African context. I believe that that it's important that this bill gets passed so that we test its utility, particularly with the growing climate of intolerance in South Africa. I believe that the bill can create a mechanism in which we're able to deal with hate-related crimes. And I believe that even though in legal technical terms, it might be difficult for us to come to some particular agreement in terms of what constitutes hate, and be happy with a very pure universal declaration. I think that this bill should be passed, and we should be able to be afforded. It should be able to be afforded, to be tested in practice, because I think that there is the climate of intolerance and hate does necessitate that we do something about it. So I think that definitely there is relevance.
Okay, thank you very much, Ms. Sipho Tekele. Honourable members, I think we'll move to the next presenter. Yeah, thank you very much, Ms. Sipho Tekele. I sorry, when you said that you could provide us with your presentation, I think I interrupted you at some point.
Yes,
I think,
yes.
if you can just provide Secretariat, I think that would be appreciated.
Okay.
But we don't dictate how you should present to us. You can even talk to us as members,
okay,
because we do have your written submission. But let me thank you once again for the oral submission and for responding to questions.
Thank you. I'll share the presentation accordingly. Thank you.
Thank you very much. On members, we'll then move on to the next presentation. All right, it's the International Religious Freedom Roundtable, I would imagine Africa. I just said I have two names on this program. We have is it Honorable Rolling A. van Broekhoven and Ms. Carmen Miller. Okay, I see Honorable Rolling van Broekhoven is on the platform. Welcome to this session. We've received your written submission as well as we're excited that you accepted to make an oral submission to the committee. We'll be giving you 15 minutes at least to make your input, and thereafter members will interact with your input. Let me then hand over to yourself, but you could focus on what your issues are with the bill and what your proposed recommendations are.
Sure. Thank you very much. Your Honor, Ms. Sheikh, Committee Chairperson, and the honorable members of the Select Committee on Security and Justice, Parliament of the Republic of South Africa. Thank you for this opportunity to meet with you on such a significant bill. It is with great honor and privilege that I've been invited to address you regarding this bill, the amendment to the Prevention and Combating Hate Crimes and Hate Speech. I am Judge Roland A. van Broekhoven of Washington, D.C., now a retired federal judge, and am active in civil society as a law professor in China for jurisprudence, constitutional law, human rights, international religious freedom. For the last 15 years, I've been an active member of the International Religious Freedom Roundtable based in Washington, D.C., which is composed of religious freedom advocates from around the world. We meet weekly to discuss laws and practices from around the world, and at least once a month with the U.S. Ambassador for International Religious Freedom and senior government officials. I'm also on the board of directors of the Institute for Global Engagement. I was raised in Guatemala, and it was there where I first became aware of the importance of freedom of religion of all religious groups, and thus started my global engagement in society on this very subject. Moreover, I came to understand that the dignity of human beings required such protection, since we are all created in the image of God with free will. I was last in Cape Town at the invitation of Mr. Michael Swain and Ms. Daniela Ellenbeck at the Sub-Saharan Summit on the Rule of Law and Freedom of Religion, South Africa. It was at that summit, made up of leaders of religious freedom, civil society, and some members of South African Parliament, that I became aware of this bill, or the B version of the Prevention and Combating of Hate Crime and Hate Speech. The threat that it posed to South Africans' right to religious freedom, particularly with respect to its proposed maximum jail sentence of 8 years, even for the first offense. My sense is that none of us who are representatives from multiple international organizations and actively engaged would be protected from such jail sentence. As a scholar and professor of jurisprudence, I have long held the belief that law is pre-political. That is, that the basic rights and obligations of law existed prior to the existence of government. I believe that this is consistent with the Declaration and elimination of intolerance and discrimination based on religion or belief, proclaimed by the General Assembly and ultimately embedded in the Charter of the United Nations. Indeed, Article 1 proclaims this right of freedom of thought, conscience, or religion, includes the freedom to have such a belief or religion either individually or in community with others, and in private or in public, and to manifest that belief or religion in worship, observance, practice, and teaching. Article 1 of the Universal Declaration of Human Rights states, quote, all human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in the spirit of brotherhood. The question that this version of Bill 89B, the Hate Crimes, Hate Speech Bill, presents to me is whether or not we are endowed with reason and conscience so that we are encouraged to act toward one another in a spirit of brotherhood. My prayer is that its final version and it's enacted in law, that it will do just that. Section 15 of the Constitution of the Republic of South Africa clearly affirms the fundamental right of freedom of conscience, religion, thought, belief, and opinion. Notwithstanding the clarity of this language in many constitutions around the world, we know that these protections are violated in the course of one's practice of its conscience, religion, thought, or belief and opinion. For those of us who think theologically, we attribute both the need for such political protection as well as the failures on the part of the government and public due to the fall or original sin. But the alleged failure on the part of the public occurs largely due either to the government or public objection to the practice of one's faith, religion, or belief. Thus, what is really protected in such laws is the private opinion or belief held by the practitioner, not the living out of that belief or faith in practice that may be consistent with the belief or religion. The South African Constitution and various international agreements to which it is committed require South Africa to uphold the right of freedom of expression and the right of freedom of religion. As a stranger to your country, I also, as a former United States judge who has practiced international law for over 55 years, it appears to me that the bill can be read so widely that it would result in South Africa's failure to meet its obligations under international law. My judicial philosophy and method of interpretation has always been what we call in the United States as an originalist. That is, words mean something. When words are so fluid in statute or in our system or in common law where we rely on precedents such as I have, they simply lose their original meaning. Thus, one of the purposes of law is to be predictive and instructive, not only to judges and lawyers, but to the population generally who are bound by those words. The wide definition of hate speech in this bill is wider than required by your Constitution and by the Universal Declaration of Human Rights and the International Covenants on Human Rights. Enforcement of this bill would result in could result in South Africa's violation of those principles of non-discrimination and equality before the law, and the right to freedom of thought, conscience, religion, and belief. Further, your Constitution contains 4 grounds for hate speech: race, ethnicity, gender, and religion. As we have seen in the United States, these terms are fluid. While race and ethnicity are still quite firm, gender has been moved from a biologically and grammatically based term to one that is sociologically determined by individuals or claimed to be in biological transition, with some 90+ genders now from which they can choose. Similarly, religion has lost some of its identity, to the point now where the nuns, Nones, seem to be the prevailing non-aligned religious preference. As a practicing religious adherent and lawyer, it is objectionable to me to have any such limitations, including religious expressions based on centuries or even thousands of years, which have been constitutionally accepted now, unacceptable in free and democratic society. Speaking as an American, it is with sadness that I acknowledge that in the U.S. and around the world, traditional religious views which have been held for centuries, such as marriage, sexuality, and gender, which I regard as a grammatical term, are coming increasingly in conflict with political and social views in society. As one who has been active in the international religious freedom movement, both in the United States and around the world, particularly in China, it pains me that the irrationality of the Amendment B version of the Prevention of Hate Crime and Combating Hate Speech could rob me and others of our dignity, as well as our existence as human beings functioning in a free and democratic society. While I make no pretense to be familiar with South African law and society, as an outsider, I urge the Select Committee to seriously consider the concerns of those who have spoken here today and will speak, especially those far more familiar with the legal and social framework of South Africa, some of whom I know. Moreover, as a believer and a religious practitioner, I am especially concerned about how this amendment would affect those of us who are committed both to our faith and to civil society. It is important to us not just to be citizens of South Africa, to understand that our religious freedoms and obligations are protected from any threat of criminal sanction, although by conscience we might have to experience such a sanction. I thank you for this opportunity to express myself to you on these matters. As a stranger to your country, but one who has been there a number of times, I love South Africa and wish the best for it and its people. Thank you.
Thank you very much, Honorable Van Broekhoven, for your presentation. Honorable members, are there any questions for clarity? Honorable Mikolakis.
Thank you very much, Chairperson. Thank you for the presentation, Judge van Broekhoven. The questions that I'm going to ask, I'm not quite sure whether the legal system in the United States is comparable to South Africa's in the same way that the UK's is, but I hope you will be able to help me with some of the questions that I have. The first one is that we have heard from earlier speakers that it's difficult to define the concept of hate legally, and if it cannot be defined, would it not be, some would argue that if you can't define a specific concept in a criminal statute, that it almost becomes either uninterpretable, so no one would know before they are in trouble that they have actually committed a crime, or that it would be left open to the courts to interpret it, which is also, according to some of the persons we've heard, problematic. The same goes for the current definition that this bill has for harm. We heard yesterday from a university professor who said that she'd prefer the definition of harm to be as wide as possible so that the courts can add flesh to it. I would just like to hear your opinion on that. In my opinion, when criminal law is made, the definitions have to be very, very clear beforehand so that everyone knows exactly what it is that they can and cannot do. It can't be decided when you're in court only. But I would like to hear your opinion on that. Then the second one is some of the arguments with regards to the 8 years maximum sanction that you have mentioned are that this is only a maximum sanction and that it can be much, much less. So we need not worry about an 8-year maximum sanction. That's only reserved for the most serious cases. And I would like to hear your opinion on that as well. Then, yes, I was covered by those two. The third one that I want to ask you is, we have heard an earlier argument that the section 4 subsection 2D gives exemption to persons on the basis of religion. Now, whether it does so, whether that section is perfect or not, we'll still debate. There are questions about that. But one of the arguments were made that on a constitutional basis, it's questionable because certain rights like that should not only be afforded to persons based on their religion, but also to persons who might not be religious. They should be afforded the same right to express themselves in that way. And therefore, due to the fact that that exemption excludes a big segment of, or a segment of society, it should also be considered unconstitutional. So those are the three aspects of the bill which I would very much like to hear your opinion on and your perspective as well. Thank you very much.
Thank you. I think to a certain extent, I addressed one or two of them in my initial remarks, although very briefly. I'm an originalist, and I believe that words in statutes or regulations mean something. And when they do not mean what they purport to mean, people in the general public are prone to be subject to criminal prosecution or criminal procedures. To that extent, as an originalist, I don't think that judges have complete discretion to decide what words mean or what they do not mean in Constitution or in statutes. I think there's probably a little more discretion in regulatory language. But for the most part, I agree that if somebody is to be held accountable for violating a law, that law should be clear enough for them to know that they are violating it. So that, I think, covers most of your first question. Is that correct?
Thank you very much. Yes.
Okay. Your second question, I think probably is a little broader. And maybe I'm jumping to the third. I believe we all have these rights and they're applied equally. That's why I mentioned the sociological studies of religious and beliefs and opinions on the basis of nuns. There are a lot of people in the United States that do not want to declare themselves as non-believers. So they simply identify themselves as not holding to a particular religion or belief. And those have been generally described as nuns, or N-O-N-E-S. My sense is that the nuns are entitled to all the rights that those of any religious group adhere to. I think that's part of humanness. It's part of the dignity of the human person. And my personal belief is, unless it is openly harmful, it's not something that should be prosecuted criminally. If there is an issue with it, there are civil laws in most countries that address that issue. Now, what I have discovered in China is the government largely dictates what the belief system is. Just as an aside, the government dictated, the Communist Party dictated some time ago that crosses must come down from behind the altars. And there was resistance among the registered churches. The unregistered churches, or house churches, generally are illegal anyway, and they ignore all of this. But when President Xi Jinping issued that order for those churches that refused to take the crosses down, he required a portrait of Mao Zedong on one side of the cross and Xi Jinping on another. And when I spoke to the head of the Religious Affairs Bureau about who came up with that idea, I said, "Did you not know that those were two thieves on either side of the cross?" And so that has kind of been picked up by a number of people over there. The church I attend in Beijing has its cross still behind the altar and no portraits. So my sense is that we are free to believe, and all of us should be treated equally. Now, I forget your second question, and I think I omitted it. What was the second question?
Chairperson, if I may.
Yes, please, Honourable Mikulakis.
Thank you, Chair. No, the second question was very much the second question was the one about the 8 years maximum sentence, that the argument from some that it's only a maximum sentence.
Well, that may very well be. And as I said, I am not really knowledgeable about either the workings of your juridical system, but my guess is that if you leave it up to judges, we tend to be arbitrary. And some of our arbitrariness comes from public views. And my sense is frequently, to put it in your context, that 8-year sentence depends on more than simply the practicing of one's belief or what one's belief system is. It may apply to issues of ethnicity, background, history. You've got a history that I have followed fairly closely for 40 years, I guess. And my guess is that if you're prone to have a judge that is reasonably arbitrary and has not completely emotionally and intellectually moved away from that history, the punishments would be uneven. Notwithstanding the fact that, as you point out, it's an 8-year maximum. Whether that becomes a maximum for a first offense or the nature of the offense, or whether it becomes a maximum in terms of just some other grounds, political pressure, I don't know. My guess is that is a bit of a red herring for those that are interested in pushing the bill. And I respect South Africa's ability to promote its own laws consistent with its history and background. And so anything I say is not critical about that. But we as humans tend to do what we do without regard to what our background is. And so I would say that the 8-year maximum may or may not be a true picture of what the bill would ultimately promote.
Now, thank you very much, Honorable Judge, for your responses to those questions. Let me also thank you and your institution for making also an input into this bill. Thank you very much.
Thank you.
Much appreciated. Our members, we'll move on to the next presentation. It's the Aurum Institute. Ms. Maria Sibagnoni, are you on the platform?
Yes, I am. Thank you very much.
No, welcome to this public hearing. I think we should also thank you for your input into this bill, as well as your presence today to make this presentation. We'll be giving you 15 minutes to do that. And if you could please focus on what your issues are in relation to the bill, as well as what recommendations that you may have. Please, over to you.
Thank you very much to the Select Committee for inviting us as Aurum into this important platform, for us to engage with the hate crime bill. Can I check? Can you see my screen?
No, we just see you.
Oh, okay. Let's try again. Did you give me the right to share?
Yeah, it looks like you do have those.
Okay, let me see now. Are you able to see my screen now?
No, we cannot. But you're welcome to continue with your presentation because we do have your submission.
Okay, perfect. So my name is Maria Sibanyoni, and I'm the Senior Technical Advisor for Key Populations at Oram Institute. We are based in Johannesburg, and our submission was focusing on corrective rape. Therefore, my presentation will be really talking to corrective rape. Just to give you a bit of a background about who is Oram. Oram is an African organization that was founded in 1998 with the aim of improving global health in research, and the research is done in many fields. We're also supporting Department of Health in systems strengthening and service delivery, focusing on HIV and TB. Sorry. In terms of the operational activities, the organization is led by experts of international teams that is managing all these multinational projects. We have footprints in Ghana, Mozambique, and South Africa. So in October 2019, Oram then introduced the pop-in clinics. These clinics are funded by CDC, and they are catering to the specialized health needs of the LGBTQIA+ community. And our focus is more or specifically on men who have sex with men and transgender women. And we are currently working at eHlanzeni, eThekwini, Tshwane, and Ekurhuleni. So these clinics, they provide comprehensive package of services that includes psychosocial support and sexual health care services. Now, when we look at the bill that we are talking about today, it is a very critical issue that demands everyone's attention. So by supporting this bill, we are sending a very strong message that hate has no place in our society. So therefore, this calls all community to stand together and ensure that justice is served for all the hate crime victims. Corrective rape is a serious crime, and it actions qualifies as a hate crime because of the violent behavior of the rapist. We have actually read and we've received report on how the victims were gang raped, victims were brutally assaulted, and how they were killed in a barbaric way. South Africa has been experiencing a series of these incidences of rape, and in which LGBTQIA are the targeted and they're often murdered. So therefore, corrective rape is a matter of agency. Fundamentally, if we look at the corrective rape, it has got two dimensions. The first one being it's a violence against women. And as a country, we are currently sitting with a high rate of gender-based violence, that we are facing as a country. And this adds to that, incidences. And the other one is the homophobia. Despite the fact that our constitution, accommodates and sexual orientation is enshrined in our constitution, but we still find people that are homophobic. So corrective rape, it needs to be classified as a hate crime. If we look at the Promotion of Equality and Prevention of Unfair Dismissal Act of 2000, it prohibits the hate crime that is committed amongst people of a specific group. Therefore, our basis is then on that, act to say that this corrective rape needs to be classified as a hate crime. Currently, if we look at the state of what is happening with the LGBTQIA plus community in South Africa, we've got a beautiful constitution that is progressive. It actually guarantees the right to equality and prohibits discrimination based on sexual orientation. But despite everything, in our constitution, we're still faced with the problem of homophobia. There are lots of incidents of corrective rape amongst lesbians in South Africa in the recent years. And having worked with the LGBTQI communities, we're also receiving reports that it's not only lesbians, it's also transgender women and men who have sex with men who actually, they also experience the same corrective, rape incidences. So the problem is broader than the lesbians. It's wide. Although South Africa has come from a most progressive legislation, like I said, I've quoted the constitution pertaining to LGBTQIA community. Many still feel mistreated by community. They feel unaccepted. They are stigmatized. They are humiliated. They are hated to the core. It's actually unbelievable. Now, in South Africa, it is believed that lesbians from African communities are the most prone to fall prey to this crime. And this is due to their cultural environment. Because in African countries, we've got this values system. And those value systems, they are prescriptive in a way of how a woman should carry themselves and how they should uphold themselves. And those values, they actually are the ones who are exacerbating the incidence of corrective rape, because if a woman doesn't conform to those norms and values, then they are seen as social deviants. The intention coupled with violence behavior of the rapist may qualify the action as a hate crime. However, what is worrying and also what is of concern, the bill is not clear and does not mention or even categorize the corrective rape. It could be useful for the bill to examine the current legal position regarding the corrective rape and how it actually shapes the norms regarding the sexual orientation. It is furthermore questioned whether corrective rape should it be classified as a hate crime. Because when we actually went through the bill and we didn't see anything that is addressing the corrective rape that is so crucial and important in our LGBTI communities and the community at large, we have seen that there is a big gap there. So therefore, the question that needs to be raised at this point, I guess, is whether South African legal framework, does it adequately addresses the scourge of corrective rape in the light of the aims of transformation of our constitution? So therefore, as ORAM, we really feel strong that corrective rape should be categorized as a hate crime. And we feel strongly about that. Thank you very much for the opportunity.
Thank you very much, Ms. Sibanyoni, for the presentation and raising those issues. I'm just going to, members, are there any questions that you want to ask for clarity? I think the proposal made was quite clear around the inclusion of corrective rape as a hate crime. Are there any questions of clarity? Okay, if there are none, let me thank you very much, Ms. Sibanyoni and your institute, the Aurum Institute, for making this input into this bill, as well as coming to present to the committee today. Much appreciated. Thank you.
Thank you very much.
Okay, our members will then move on to the next presentation from the Film and Publication Board. Yes, Mr. Andrew Sivaku. Are you on the platform, please?
Yeah, Honorable Chair, can I just request that maybe the next presenter, present, because Dr. Mashilo Buluka, who's gonna do the presentation, was just held up, especially after we had to be disconnected, but he is connecting. So if the next presenter can just present, and then I will let you know as soon as he is connected.
Okay, thank you very much. Is Mr. Pierre Brouard present or on the platform from PATHSA?
Chairperson, Mr. Brouard was only able to come at that specific time. I'm just wondering if we could move to the next.
Is Ms. Kim Lithgow? I think you are present. Okay, from same Toti Love, Ms. Lithgow, welcome to the platform. Are you on the platform? Ms. Lithgow, are you on the platform? Kishan, I'm not getting Ms. Lithgow. All right, I'm not sure which, because the next one after same Love Toti is the Scalabrini Center of Cape Town, Mr. James Chapman. Okay, I don't think he's on the platform. Is Dale Wallace on the platform? All right, and then there's Mr. Matthews Cuthbert from the Democratic Alliance. Okay, I know they scheduled for much later. All right, our members, looks like we're gonna perhaps, Gershwin, I don't know if you're able to make a follow-up with anybody that's on the platform. They might be waiting for their time. Yeah.
I will follow up.
So from the Film and Publications Board, I guess you were scheduled at 4. The time now, okay, I see we've picked up the pace. All right. Our members, what do you say? You take a tea break? Mikalakis.
Chair, I just wanted to say a smoke break / tea break would be very, very well. Thank you.
A tea break, yeah. For most of us that don't smoke. Look, I propose, look, it's 3:30. Well, can we maybe take a 10-minute break? And in the meantime, Gershwin perhaps can maybe make a follow-up with any one of these institutions if they can be available, and maybe give us feedback thereafter. So a 10-minute break, I think, would be quite good for all of us. Or members, it's oh man, my watches, all of them give me a different time. It's 25 to, so at 2. Can we all then reconvene?
Thank you, Chair.
Recording stopped.
Gershon, I'm just checking in if the Film and Publication Board is ready, or should we move on to the next one?
If we may move to the next one while the CEO is getting ready.
Okay. Okay. I think Ms. Kim Lithgow, you are on the platform.
Yes, I am.
Are you willing to go with your presentation now?
Yes, I can do that.
You can do that. Okay, before that, on members, are we back? Are we in the meeting? It's past 1:45. Yeah, I think members are here. Okay. Okay, Ms. Lithgow, thank you very much. Your input is from an organization called Same Love Toti. I hope I'm pronouncing it properly. Let me take this opportunity.
Great, yes.
Okay. Let me take this opportunity to thank you for your input, as well as for coming to the committee to make an oral presentation. As I know you've been in the meeting for a while. We'll give you 15 minutes to make your presentation, and if you could please maybe focus on what your issues are with the hate crimes, hate speech bill, as well as what recommendations you'd like to make. Over to you, ma'am.
Thank you very much. Thank you for giving me this opportunity to deliver the oral presentation.
Recording in progress.
The hate crime and hate speech bill. You should all have a copy of the Progressive Prudes report and the Hate Crimes Working Group Advocacy Brief of 2022. I will be referring to statistics in those documents. So my name is Kim Lithgow. I'm founder and CEO of Same Love Toti, a registered human rights-based non-profit organization that is dedicated to advancing LGBTQ rights in South Africa while offering support to sexual and gender diverse minorities and their families. I am the co-chair of the Hate Crimes Working Group, the member of the Gender Diversity Coalition, the Social Inclusion and Education Working Group, and other coalitions that strive to foster equality and inclusivity in South Africa. In July this year, I also delivered a statement to the United Nations on the inclusion and safety of LGBT in relation to the Sustainable Development Goals. So, regarding this bill that we're looking at today, I think it's important to acknowledge that in South Africa, hate crimes happen. Hate crimes happen in South Africa, hate speech happens in South Africa, and that is why we need to make it a crime to commit a hate crime or hate speech. Delaying hate crime legislation makes us the most hypocritical country. We are so proud of our progressive constitution that prohibits discrimination, making us a leader in Africa and far ahead of many other countries. But we have yet to criminalize the most extreme expressions of discrimination. In other words, hate crime and hate speech. We cannot be satisfied with current legislation that has resulted in a few convictions when we know that 80% of all LGBT hate crimes are not reported. We also know that 3 million people have openly admitted that they might in the future be violent towards LGBTI, and more than 1.5 million openly admitted to hate crime and hate speech against LGBT individuals. And this is why we need to pass this hate crime and hate speech bill as soon as possible. It is long overdue. We have had research on hate crime and hate speech from 2009. We've been working on this for ever since then. So now in 2023, it is long overdue that we actually implement this bill. Hate crime legislation safeguards the fundamental human rights of all individuals, especially when the majority fail to fully respect the rights of minorities. We are here debating the definition of hate, but hate crime victims do not debate the definition of hate. The definition of hate is written on their broken bodies. The definition of hate is written in their blood, their spilled blood. So go to the funerals, sit with their families, and that is where we will find the real definition of hate. Nonetheless, it's heartening for us to note that the majority of South Africans believe that lesbian women, gay men, transgender people, intersex individuals, and all sexual and gender diverse identities should enjoy the same human rights as everyone else, despite their differing views on same-sex relationships. And this is why we come before you today, to advocate for our basic human right to live without fear or prejudice in a democratic society. Our freedoms come with obligations and responsibilities. In the past, many South Africans were denied their freedoms. So today we committed to upholding those freedoms. However, these freedoms need to also be respectful of people's dignity, equality, and freedom. If we look at freedom of speech, we know that offensive speech is not hate speech. No matter how many times the issue is raised that offensive speech could land somebody in jail, offensive speech is not hate speech, and this bill does not criminalize offensive speech. Hate speech, however, is perfectly defined by the Constitutional Court in the judgment against John Xolani, and likewise in this bill. It's also fitting to remember that hate crimes are preceded by hate speech. Therefore, if we can curb hate speech, we can also curb the instance of hate crime. And likewise, if we can curb incitement to violence through hate speech, we can also curb hate crime. Freedom of expression is very similar. We are free to express ourselves, but we're not free to engage in hate speech or hate crime. We're free to express ourselves, but we may not violate the rights of others. Other people have the right to express themselves too. And again, we need to respect that right. Sorry. Freedom of religion. Freedom of religion does not mean the freedom to commit hate speech or the freedom to commit hate crimes. It is possible to speak about one's faith or belief system, respectfully acknowledging that others are free to make their own decisions, they are free to make their own choices, they are free to have their own faith and their own belief system. And simply respecting that does not dilute one's own freedom of religion. Respecting the dignity of someone who may or may not agree with you also does not restrict one's religious freedom. And acknowledging that others have a right to have their own beliefs does not dilute one's own faith system. So I don't think that freedom of speech or freedom of expression or freedom of religion can be used as an excuse to not pass this bill. Finally, is this a perfect bill? No, It might not be perfect. There might be flaws, but none of the flaws are so grave that they would require us to delay passing this bill again. It's been 27 years since the adoption of the Constitution, and we are still grappling with discrimination. We are still having an escalation in hate crime and an escalation in hate speech. And after 27 years of trying other avenues to foster social inclusion and a live and let live attitude, it is now time to criminalize extreme forms of hate and violence and hate speech. This bill will save lives. It will uphold our own constitutional obligations. It will protect the freedom of minorities, and it will prevent hate crime and hate speech. It's imperative for the South African government to take a resolute stance against hate crimes and promptly enact this vital legislation. Hate crime legislation yields invaluable statistics, enabling us to craft effective strategies for preventing hate crimes, for raising awareness, for preventing intolerance, and curbing discrimination. This bill puts onus on state to provide training and raise awareness on the implementation of this bill. And it will also put the onus on the state to access justice for the victims of hate crime and hate speech. As responsible citizens in a democratic nation, we wholeheartedly welcome a bill that is dedicated to preventing hatred, to preventing bias and discord amongst our people. We embrace a bill that promotes unity and respect for all individuals, combating violence that is rooted in discrimination and bias. It's a bill that can save lives and can encourage coexistence. It can build communities. In a nation with a history marked by shameful discrimination, we bear the duty of ensuring that discrimination will never tarnish our future. And therefore, I implore Parliament to pass the Prevention and Combating of Hate Crime and Hate Speech Bill without delay. Thank you.
Thank you very much, Ms. Lithgow, for that presentation to the committee. Honourable members, are there any questions for clarity? Honourable Mikolakis.
Thank you very much, Chairperson, and good afternoon, Ms. Lithgow. I think, Chairperson, it's important to start. Firstly, thank you for the presentation. I think it's important to state, I can say this with confidence about my colleagues from all parties represented on the committee, that we are all in agreement that hate crimes and hate speech is not okay. Bigotry and homophobia is also not okay. But we are lawmakers, and it's our duty to make sure that the best law out there, or that the law that gets passed through Parliament is the best version of the law out there. So in the process where we ask these questions, we are seeking the best possible version of the bill, because bad law has serious negative consequences ultimately, and it doesn't go any far to really come up with solutions to serious social problems that we are facing. And this is a very serious social problem. And especially if you're dealing with criminal law, it needs to be very, very clearly defined so that everyone knows what is allowed and what is not. So part of the questioning is very much based on trying to find a solution so we can put the best version of this bill out there. You have indicated that Kwelane was used in the Constitutional Court to put certain definitions or concepts out there. Would you say that the bill needs to be brought in line with what was stated in Kwelane? and that it should bring that legal certainty. That would be my first question. My second one is, I am going to carry on about the definition of hate. I understand completely the argument that you made, but for purposes of the bill, we need to define it, in my opinion. And I would like to know, do you have some form of a definition that we can look at and use to try to bring that legal certainty when we look at a final version of the bill? Thank you very much, Chair. Thank you.
Thank you very much, Honorable Mikalakis. Honorable Dodovu.
Thank you very much, Honorable Chair, and thank you very much for the presentation. I think it is an appealing presentation that speaks to say to us as members of Parliament, let's do something with the serious matters that we are confronting, and thank you for that. Just one question. What is the comment of the presenter in relation to the sentencing, the maximum sentencing that is proposed in the bill? Thank you, Chair.
Thank you very much, Honorable Mikalakis. Ms. Lithgow, if you could perhaps respond to those questions.
Thank you. And thank you very much for the questions as well. So regarding the John Xolani case, I do believe that Constitutional Court did, do a good job of defining hate speech there. And yes, I do feel that that is what we would be aiming for. I do also, though, think that it's sufficiently laid out in the bill as it stands. Although, like I said before, although it might be not 100%, okay, what we want. I mean, when is it going to be 100%? We've been working on this since 2009. So I think that if we're just going to sit and sort of nitpick about things, I don't think that we're going to get very far. And this is why I think, look, we've worked on this bill. We've fine-honed it for as much as we can. And even if it isn't 100% that everybody can agree on it, I still feel that it's sufficient to be enacted now. I also think it might be to remember that we could pass the bill now and then only enact the hate crime, the hate speech part at a later date, if I'm not mistaken, unless we've not gone past that and we're not allowed to do that anymore. But at one stage, I knew that that was an option. So maybe that's something. But I still believe that we need to get this done sooner than later because lives are being lost. And yes, it's not perfect, but I don't think any of our laws are perfect. And yeah, so I think it's time for us to just pass this law now. As far as the definition of hate goes, I still think it's really it's kind of really simple. I think we're trying to, make it so complicated where it's really, really simple. The definition for me for hate would simply be something that takes away the rights of others. Something that encroaches on their dignity, their equality, their freedoms, all of those types of things that we are aiming to build in a democratic country. We're aiming for social inclusion. We're aiming for people to be able to fully live their lives, So I think those types of things, whenever it comes to human rights, if the human rights of somebody have been taken away, there's a good chance that it's going to be classified as hate. especially when we do look at hate crime victims. You know, I really think that simplifies it superbly for us. I'm not sure if that's a sufficient answer. And then regarding the sentencing, it's the maximum sentence, isn't it, of 8 years? And yeah, whether that is excessive or not, I don't think that it matters too much, because, you know, I think people would rather go for a minimum sentence anyway. So I really don't think that it's something that we need to be overly concerned about. I think, just in wrapping up, I just feel that this bill needs to be passed. I feel that it will help in our fight against hate crime and hate speech. And I think it's long overdue that this needs to happen now. So, yeah, that's it. Thank you.
Thank you very much, Ms. Lithgow, for your responses to members' questions, as well as for your input in this. So, yeah, much appreciated. Once again, thank you. Members, we'll then move on to the next presenter, and I'm hoping the Film and Publication Board is ready. Mr. Sibapu, yeah, it's past 1600 hours. Mr. Sibapu, are you on the platform and ready?
Thank you, Honorable Member. Dr. Buluka will do the presentation. If I may be allowed to project from my end the presentation.
Okay, yeah, you'll be given those rights, but let me welcome you and your colleague formally to this platform, and thank you for making an input into this bill, as well as coming to make a presentation to the committee today. We'll be giving you 15 minutes to make your presentation. Thereafter, members will engage with you, especially around questions of clarity. And we're requesting that if you can focus on what you think the issues are with the bill, as well as what recommendations you would want to make as an organization. Over to yourself, Mr. Sibapu. Or is it Mr. Boloka?
Yeah.
Mr. Boloka will be beginning. Okay, Mr. Boloka, over to you.
Thank you very much, Chair, and honorable members. And as the FPB will appreciate, we appreciate the opportunity granted us to make an input in this crucial bill. For us, in principle, we support the bill because I think it's very important that South Africa, we deal with this matter. Thank you, Mr. Sibapu, for the presentation. I think just to go to slide 2. Our presentation covers 2 parts. The first part is on in general terms, like who we are as the Film and Publication Board. This is so important, given that not many people in South Africa know about the Film and Publication Board and what it does and the regulatory powers that it has, particularly around this topic that we have today. Because out of that, we say there are currently some mechanisms that have been developed legislatively. So let's look at ways in which we can strengthen that. I mean, for instance, the definition of hate speech. There are some penalties that are in our act as well around the same matter. Then the second part of our bill, our presentation will cover our specific reference to the bill itself. In other words, where we respond to the draft bill itself. But of major importance, which is quite key, is I think the resemblance between this bill and our act. Therefore, it's so unfortunate that I think the drafters never referenced the Film and Publication Act that came into operations on the 1st of March last year, 2022, because I think it will, one, strengthen the some existing mechanisms that we have. If you go to the next slide, Mr. Sibampo, the FPB is a statutory regulator. We are an online regulator, which in terms of the Amendment Act, we exist to protect the public against what is defined in the Act as harmful and prohibited. And I want to emphasize prohibited content because that which you call hate speech is defined under that, which means it's content that has got the potential to cause propaganda for war, incitement of violence, advocacy of hatred based on identifiable groups and constitute harm, and therefore is prohibited in terms of our act. In other words, hate speech currently is prohibited in terms of our act, section 16 of our act. Hence, we regulate it, and I think we'll share with you how we regulate it. Second slide, Mr. So what we do, we classify. To deal with hate speech, we classify with movies and regulate the classification of movies or games that purport or that distribute or that promote hate speech. We classify them so that is classifiable materials. And secondly, which is quite critical, because hate speech has moved to online, which is where we play, we register most of the social media platforms, whether it's your Google, your Netflix and so forth. They register with the FPB for them to distribute content in South Africa. And in addition, we conduct online safety and public education on online harms. Hate speech is considered as one of those online harms that we deal with. Next slide, quickly. So for us, really, this is the vision that we have as the FPB, that we want to create, in line with the NDP, a safer online communities free from hate and harm directed at the public, particularly the vulnerable groups. And for that purpose, that's why hate speech is included in there, including misinformation, sextortion, and those kind of harms that I've included there, including online gender-based abuse, because some of them, I think, are drawn from that. What are the regulatory powers? Like I've already mentioned, I think we register most of the social media platforms who are the distributors of some of the hate speech that we are talking about, unless if they are regulated. And next slide. Now, what is it that the FPB has internally? So because one, the reason why hate and hate crimes are so critical to us as the FPB is because one, they are distributed via the internet and social media, and that's where they make a lot of impact. And if not adequately regulated, they may incite violence. They hates. They can cause harm, and therefore that's why we have identified the social media platforms as cesspits of hate. I think we are working with this organization called Center Countering Digital Hate Speech, because a lot of it happen online more than the physical environment. Next slide. Now, the other part that is very important is that sometimes we think of hate speech as only a political tool or a social tool. It is equally a commercial exercise in which there are websites or organizations that post this thing because it generate money for them. If you look at most of the hate posts that are on online, some of them have got advertising next to them, which are nothing to do with political affiliation or anything of that sort. They are really spurred or triggered or fueled by the need for commercial gain. Hence, we need to regulate the social media platforms on that. So a lot of it has shifted towards online, and technology has enabled them to spread fast. I think you can refer even to some of the Elon Musk's tweets and so forth. So what are the capacity that we have as the FPB, which is the next slide? It's more about, because as the FPB, we have content moderators that consistently look at what you call prohibited content. Now, prohibited content includes the hate speech and hate crimes as we mentioned it, because for us it causes harm and can cause violence. Next slide quickly. And what you do, like I mentioned, how do we deal with it? We classify material. In other words, material that, whether it's a film or game, that promotes hate speech, they have to be classified by us in terms of Section 16 because they are anyway prohibited. And secondly, we do monitoring and takedowns. In other words, if there's a material that we feel is promoting hate speech, what is it that we do? We can either do a takedown ourselves, or we can request a platform owner where the material is being distributed to take it down. And then we've got compliance monitors and content moderators who has got that responsibility within the organization. Next slide. Now, how do we, because that's very important, it's a very thin line between that which you call freedom of expression and authoritarianism. So what you do as the FPB, when we deal with the issue of hate speech, for instance, we don't act on our own. We wait for a complaint to be lodged with us. Once the complaint is lodged, that's when we act. We do what do you call it? We then investigate, and then if there's merit in the matter, and that's very important, for us, the first line of defense against hate speech are the social media platforms, because those are the ones that we regulate. Then we ask them to, we take the matter to the enforcement committee, chaired by a retired judge. If the verdict of that enforcement committee is not something that members of the public are happy with, they can then petition what you call the appeals tribunal, which is also provided within our own law. This is to ensure that the decisions that we take are not necessarily infringing on the freedom of expression. And we work with the internet service providers, the social media platforms, to ensure that indeed that which is right. And then, as we mentioned, the Section 24 of the Act provides that any person or social media that distributes a game, film, or any material that is prohibited, in other words, propaganda for war, incite violence, which hate speech does, and it will be fined an offense of 150,000 or imprisonment for not exceeding 2 years, or both fine and imprisonment. I think that's where I mentioned earlier that there's some mechanism currently. I think for us is how do we cross-reference this material, depending on which one will deter the matters of this nature. I think we can settle it, but we support the bill in its own. Like I mentioned, the issue of public complaints that we deal with. But the most important thing is, as part of this activity, one is we are working on industry code with online distributors on how will they prevent online harms, including hate speech. We normally, I think, we'll issue a notice on how do they deal with that, and then based on that, we'll see what actions we need to take. But there's also peer-to-peer video sharing material, which for us are very important, so that when a person sees a material that promote hate speech, they don't have to share it themselves. The first part is making sure that the public is aware of hate crimes or online hate speech, and so that they don't have to share it. So we're also working on the guidelines as well along those lines to make sure that this happens. Next slide. So we continue to monitor. But of major importance, I think, are some of the specific reference to the Act, which you have made recommendation to. Perhaps I should allow Advocate Lindhorst to take you through some of where we think our Act is comparable to that which is proposed here. So that I think just cross-referencing will improve a lot and make sure that as South Africa, we've got an integrated approach to online hate or hate speech as a content. Because at the moment, if this bill goes through in its current form, then we've got the FP Amendment Act. It means now, as a country, we've got the same legislative provision passed by the same legislature, but the way in which we deal with the matter are more disintegrated. Maybe let me allow Advocate Lindhorst to take you through that, or even Andrew, one of those, to deal with provisions that are comparable within the limited time that is available. I guess we are left with probably 2 to 3 minutes. Andrew or Advocate?
Thank you, Dr. Woluka. Now, there are a few, sections that are comparable between the two. In other words, between the FP Act as well as the bill. The first one relates to the issue of, the offenses and penalties. For an example, in terms of our act, the Film and Publications Act, as Dr. Woluka has indicated, it's very clear in terms of the amount of fines that one can actually be fined. It is very clear in terms of the number of years that one can be imprisoned. But when you look at the bill, it does not necessarily tell us as to the fine that one can actually get as a maximum in terms of where one has been found guilty of hate crime or even hate speech. So that is one of the provisions that we think maybe it's necessary that in the bill there is a cross-reference to the FPB Act, as it's very clear in terms of the penalty. So and again, the fact that in terms of the bill, if it speaks to criminal sanctions, in other words, one has to then refer the matter to for prosecution or report the matter at the police station. But now with the Act, the FP Act, we do have an independent body called Enforcement Committee, which is chaired by a retired judge, and then is able to deal with any complaints relating to hate speech, and then it has the power to impose a fine. But of course, where it deems necessary, it can still refer the matter for prosecution. So those are the main provisions that we think they are not necessarily aligned, and therefore it would be important that we align those sections, or the bill does make a cross-reference to those sections in the FP Act. Thank you.
Thank you, Chair. Are you done, Andrew?
Yes.
Okay. Thank you, members of the cluster. Like we said, we really appreciate the opportunity. In conclusion, for us, really, is this issue of hate speech is proliferating around the globe and aided by technology, threatening our nationhood and nation building, and therefore we must act on it. We for a country like South Africa with its racial ethnic polarization, I think we know what the dangers are. We are, as the FPB, we are a statutory organization established by government to deal with the online space. We got the act that has been passed by Parliament, so if we can assist in strengthening those, but overall we support the bill. And once again, thank you very much for the opportunity.
Thank you very much, Mr. Sibapu and Mr. Boloka, for the presentation. And yeah, I think I would see if honorable members have any questions, if they want to have any questions for clarity. Honorable Mikolakis.
Thank you, Chair. Yeah, I didn't realize there's another bill that also covers what we're dealing with in some aspects. We've heard of PEPUDA, and now there's the FP Act as well. I would like to ask the maximum sentence in terms of the FP Act. What is the maximum sentence that it imposes? That would be the first question. The second one would be our criminal justice system. Is it currently geared to deal with such crimes in terms of this act? is it at all capable of effectively dealing with it? Because what we actually want is for the issues to be addressed rather more effectively through existing law than just adding more law, and none of these laws can actually be effective. So my question would be, in terms of the current act, is the criminal justice system able to at all give effect to what we already have on the statute books? Thank you.
Thank you very much, Honorable Mikolakis. Honorable Dodovu. Maybe before you go, let me just I wanted to do a follow up with Honorable Mikolakis' question, especially with regard to the criminal justice system. But perhaps if you could also tell us what have been the challenges around prosecuting in some of these matters. Has it been easy? What have been the difficulties around this, and how many cases have actually been prosecuted, or that you're aware of being prosecuted? Honorable Dodovu, over to you.
Yes, that would be my first question. The latter question that you ask, I want to check the volume of the cases that you handle. If you can share with us, since the inception of the board, how many cases were brought to your attention, and how regularly are you disposing of these cases, and how long does it take for you to finalize the cases? The second question, Chair, relates to the work of the Films and Publication Board in relation to proactiveness. I heard the doctor saying that they are not proactive, they are reactive, which means they only act on the basis of the submissions sent to them. They can't on their own volition, when they realize that there is a violation of the law, act and approach the perpetrators in relation to the transgressions that they would have committed. I want to understand, is this how the law is, or why are they not acting proactively even when they see the cases on the table? The last one, I can see that mainly they identify two conflicting, what I call conflicting areas between the current bill and the publication, the Film and Publication Act. My question would be, what interactions did the board have with this process until it is now, starting from when the process was mooted from the side of the National Assembly to date? What interactions and interventions did the board try to make in order to address these conflicting areas that they have identified? Thank you, Chair. And I've noted those. I've noted those two areas. Thank you, Chair.
Thank you very much, Honorable Dodovu. Over to yourselves, Mr. Sibabu. I'm not sure who's going to lead with this process, Mr. Boloka or Mr. Sibabu. The responses.
Let me start, Chair. Then Mr. Sibabu will come in, and Advocate Lindhorst. The law specifies, Honorable Mikolakis, the law provides that Section 24, that 150,000 or imprisonment not exceeding 2 years. So that's the maximum, essentially, is 2 years. Whether that is a deterrent is something else. And I think we recently made a comment with I think the Portfolio Committee on Communication, where we said, you see, the dangers of putting, in particular, that fine. If you think about it, this act was discussed from 2015 and only passed in 2019. And as the FPB, in terms of the presidential proclamation, we only started implementing this act on 1st March 2022. Now, the maximum, just to say the maximum penalty there is 150. Now, what is 150, especially if you're dealing with these multinationals? It's nothing. So we said, maybe in the future, this is a lesson that you don't have to put the maximum, particularly the maximum penalties around the fines, the monetary fines, because I think that may not be determined, because we are dealing with companies that are transacting in dollars. 152 Meta is nothing. So on whether the justice system has got the capacity to deal with the problem, it will take a long time. I think about the John Gorani case, how long it took, and therefore whether the length that which it takes, I think, brings justice or is a deterrent is something else. But the issue is this: the FPB mechanisms which are provided for by law, they may deal with the matters quite speedily, in the sense that I think this is the other question that was asked, to say, how long does it take for us to finalize the case? In terms of our procedures that we recently finalized, we take 60 days. Why is it 60 days? One, there must be investigations first. That's number one. Investigation, or let's start with takedowns. Takedown, in other words, where we request an entity to take the matter down from circulation to when we do the investigations, and thirdly, when we present the matter before the enforcement committee. And then the enforcement committee can also hold public hearings on that to hear the different sides. But we said 60 days. Unlike if it goes through the court, then it will take a longer time. And sometimes, can be a very expensive process. But with ours, because it doesn't, we are being largely funded by the state, then it doesn't involve any money. So no poor person may not feel that their matter have been heard. Unlike a court process, may need a lawyer. So I think that's the advantage of the process that we have that is being built by the Act. Now, what has been the challenge on the prosecution in the matter, Honorable Shaik? Like I just mentioned, the Act that we are implementing started being operationalized on the 1st of March. Now, from a narrow classification authority that has been in existence since 1963, it never had the capacity to do regulations. So the first part was for us to build systems, to build in even regulations. And you recall that in South Africa, when you have to do regulations, you have to consult the public. So what we did, just since the Act was operationalized on March, we developed regulations. We appointed the enforcement committee late last year. It's only, and then now we just finalized the public complaint system. So we have been putting in systems. So we are yet to deal with any case, but there are cases that we are taking to the enforcement committee, I think before the end of September. That will be the test. Those will be a number of cases that we'll be dealing with for the very first time. So we'll see how, I think, the challenges when we start implementing. But the interaction with the process, maybe Andrew can reflect on that. But I don't think we have made a submission. If we made a submission to us long before this process mothballed long time ago. But let me give an opportunity to Andrew, because he has been at the FPB for a long time. I only joined FPB last year together with the advocate. Andrew?
Yeah, thank you, Doc. Advocate wanted to assist in that regard. Maybe let's give you an opportunity to also assist.
Okay, Advocate Lindhorst.
Afternoon, honorable members and chair. I wanted to respond also in terms of to share with the committee the work that we've been doing as the FPB. We are trying to strengthen on education. So we've realized that whilst the Act has come into effect last year, but it's not known by members of the public. So as part of ensuring that we test and ensure that there's efficacy of this legislation, so we've been strengthening on education and awareness. So we've been having a drive where ordinary members of the public are made aware of the existence of this act, that if there's any situation of hate speech that they come across, especially if it's distributed also through social media, that they have the FPB Act, which allows them to lodge a complaint. But also we've realized that there is a need, because we do have that criminal sanction, which is there in the Act. So we've started interacting also with prosecutors. So we have a plan where we are also bringing the existence of the Act to the prosecutors, that when they are dealing with these cases of hate speech, they should be aware. And also the police, that if victims are coming and opening these cases with them, they also have to be aware, and where possible, they advise that there is this mechanism that has been brought by the FPB Act, that they can lodge their complaint with us as the FPB. As Dr. Buluka indicated, this was our first attempt to interact with the committee and relevant committees on this act to make inputs as the FPB. So we don't have any other record whether previously was there any attempt to ensure that we bring to the attention of the relevant committees the existence of this act. So at the core of us, it's about the committee that is responsible for this bill to ensure that at least there is a cross-reference to our act. But yes, members have to complain, but because we have a surveillance team that is also doing monitoring, the team on a daily basis, they monitor, and where we detect some of those activities, it's our plan that we bring to the attention of the affected that, are you aware of the existence of our act? So we have realized that there is a need for us to be more proactive. Thank you so much, Chair.
Thank you very much to the entire team from the FPB for responding to the questions that members raised, as well as for your submission into this process. I think now that we are aware of this act, I'm sure the department is aware of it. But we'll probably take those processes forward when we continue with our deliberations. Once again, thank you very much. Members, we'll then move on to the next presentation. It's by PARTHSA. Mr. Broad, you are on the platform. Welcome to your good self. And thank you for your submission to the committee on the bill, as well as your presentation now. We'll be giving you 15 minutes to make your presentation. Thereafter, members of the committee will interact with you in terms of questions of clarity, and we'd appreciate if you could focus your presentation on what your issues are with the bill, as well as what recommendations you have. Thank you, Mr. Brown.
Thank you very much, Chair. Am I visible and audible?
Yes, you are.
Thank you. I really appreciate this opportunity. I'm not going to be using a PowerPoint presentation. You have our submission, and I'm mindful that you've probably been at it for many hours. So I'm going to talk briefly to our submission and may not use up all of my 15 minutes, in fact. So there will be more time for discussion and questions if necessary. So I'm here to represent PARTHSA in my capacity as a board member. PARTHSA is the Professional Association for Transgender Health in South Africa. It's an interdisciplinary health professional organization which promotes the health and well-being of trans and gender diverse people. Our submission is not really based on the technicalities of the bill or trying to discern the niceties of hate crime and hate speech, but rather it's to make a plea for the recognition of trans and gender diverse people in the South African landscape as an extremely marginalized minority. So as you indicated, my name is Pierre Brouard, and just by way of introduction of who I am, I'm a clinical psychologist by training. I'm a member of the executive of the Sexuality and Gender Division of the Psychological Society of South Africa, and I'm the acting director of the Center for Sexualities, AIDS and Gender at the University of Pretoria. So as background, I thought it might be useful to briefly explain the terms transgender and gender diverse as we use them in our submission and as they are commonly used in the literature and in everyday discussion of this topic. So all of us, when born, are given a label based on the presence of our external genitalia, and this usually is very uncomplicated, and our parents will be told you had a boy or you had a girl, and for most people, they grow up identifying as that boy or as that girl. But for a very small percentage of people, things are a little more complicated. They do not simply and easily identify as that boy or girl. And what research tells us is this can start as young as the age of 3 or 4, when young people will push back against the particular sex that was assigned to them when they were born. We would call the people who do not identify with that label given them at birth as transgender, or the term trans can be used as shorthand. And what trans people do as they mature into adulthood is a number of things to make themselves more comfortable in their identity. This can include, for example, what we call social transitioning, when they would dress and live as the gender that they identify with. It could also include medical transitioning. And by this, we mean they take hormones to change aspects of their body, or they may have surgeries to similarly change aspects of their body. Then the third aspect of transitioning is what is called legal transitioning. And in terms of South African law, a transgender person can apply for a name change and the change to their sex marker in the identity document. And they would have to do that through the Home Affairs Department. There is a small subset of people who do not identify as either male or female, or as both male and female. And we might include them into the category of gender diverse persons. And occasionally terms here might be things like they're non-binary or agender and even genderqueer. So as you can imagine, life is not easy or straightforward for people who do not fit into these neat categories or neat boxes. And they can be subjected to lots of discrimination and hatred. And mostly this will be based on fear and on misinformation. So what kinds of discrimination can trans and gender diverse people experience? So firstly, we would see possible rejection from their parents, their caregivers, their families, and their communities. They may be forced to dress and live in a way which feels inauthentic or even psychologically painful for them. They can experience bullying and violence and rejection in schools. Schools are very binary spaces, and they're very much based on the idea that boys and girls are very separate things and should be kept apart. And any recognition of any blurring of those boundaries is very difficult in school spaces. They may face challenges with finding work. They may face name calling and humiliation in social life. They may face rejection and humiliation in medical settings, or even denial of treatment. And I'm not only here referring to the difficulties with accessing gender-affirming hormones and surgeries, but also in some instances, there have been reports of trans or gender diverse people being actually turned away from services because they present a challenge to, in that instance, an uninformed or possibly even prejudiced healthcare worker. Then one other quite serious space of discrimination is the trans person's interaction with government departments, and I think particularly Home Affairs. And there are many reports of trans people who are trying to make legally permissible changes to their name and sex marker in the ID document, facing delays, hostility, or forms of inertia in those spaces. And then in terms of the last category, we know that also that trans and gender diverse people, when they try and report a hate crime, for example, if they go to a police station or they wish to report an assault, a sexual assault or a rape, they may face rejection and humiliation in those spaces because there's a lack of understanding that they have a right to make a claim for some kind of justice. As you can imagine, the impact of these kinds of experiences is often very damaging to trans and gender diverse people. So we see impacts on self-esteem and psychological wellness. The education and training of trans people, often trans and other LGBT youth find a difficulty in school spaces to achieve a consistent and respectful education space, and sometimes are forced to leave early. Trans people will sometimes struggle with employability and broadly the chances of living a dignified and meaningful life. What the literature also tells us is that rates of suicide and other forms of self-harm are well documented in this community. And it's not because they are inherently psychologically unwell, but it's the consistent and persistent and overwhelming impact of discrimination. So what is Path SA's position on the bill? First off, we welcome the bill and appreciate the efforts to develop a law which prevents and addresses harm towards trans and gender diverse people. We welcome the inclusion of the grounds gender identity or expression or sex characteristics as a basis for hate crime or hate speech. And we welcome the emphasis in the bill on prevention, not just prosecution. And perhaps it's worth mentioning that we note that the bill does talk about campaigns on the Act. It talks about assistance to complainants to lodge complaints. It talks about training officials on the Act, and it talks about training judicial officers. Now, in many instances, those people who are being trained will be meeting the trans or gender diverse person when the hate crime or hate speech has already happened. So there is less of a prevention effect, but we still believe that those are very important steps. What is Path SA asking for? We would firstly like meaningful resources to be made available to create a social and cultural climate of acceptance towards trans and gender diverse people. Now, again, an act such as this one cannot do everything, but we feel that it is important to recognize that changes in social attitudes towards trans and gender diverse people won't just happen through a legal process. There needs to be a broader engagement with social attitudes and how they are formed. We would like to see meaningful data collection on hate crimes and hate speech towards this community so that we can measure the extent of the problem and do better prevention work. Without that kind of data, often it's very difficult to ascertain the scope of the problem. What we're not saying is that necessarily that there will be thousands and thousands of instances, but rather the point is, even if there's a smaller number of instances, those are important to know about and to measure. We would like to make a special plea that attention is focused on school and other educational spaces, as this is a time where trans and gender diverse people face a lot of hostility and harm. In fact, we would like the bill, if possible, to specifically prioritize young people who lack the power and agency to protect themselves from harm, not only from their peers, but also from the adults in their life. Then we know that under the auspices of this bill, it's unlikely that deliberately misgendering someone. So that's, for example, when someone has indicated that they identify with a particular gender and use a preferred pronoun or title or name, and if the person deliberately refuses to use that person's preferred pronouns, etc., we probably think it wouldn't meet the threshold of being hate speech or a hate crime, but we would like to flag that as an occurrence that trans and gender diverse people face. Then, although the question of discrimination on the grounds of sex characteristics is envisaged in the Act, we would like to see more explicit mention of intersex people who are often under-recognized and under-protected in legal protections. So by way of explanation, intersex people are those who have fall on a spectrum of diversities or differences of sex development and may in fact be born with ambiguous, uncertain external genitalia, which may mean in some instances that the sex that is assigned to them subsequently turns out to be the incorrect one. And so that person would end up falling on the trans spectrum, possibly. So we want to make some kind of acknowledgement of the needs of the intersex community in South Africa. We call for discussion on possible hate crimes aimed at trans and gender diverse people to include the question of public bathrooms. Often this is a very contested space, but there's a very high chance, in fact, that given the levels of what we would call transphobia, that trans and gender diverse people, precisely because they do not fit into neat physical boxes or visual boxes could experience bullying and harm and harassment and even further physical harms in those spaces. Interestingly, the impact of transphobia is that even people who are not transgender but have an ambiguous gender presentation might find themselves on the receiving end of hate crimes in those spaces. We would also like special attention to be paid to the behavior of government officials, especially when they're working in home affairs contexts and interacting with trans people who come to make legally permissible changes to their name and sex marker and their identity documents. These are often sites of great discomfort and harm. And finally, while we acknowledge questions of free speech and religious freedom, we note with concern that often it is in these very religious spaces where stigma and discrimination happen, and call for better monitoring of religious spaces. Perhaps by way of conclusion, I could just reflect a little bit on one of the previous discussions, I think when Ms. Lithgow was being questioned about, do we need another law to be introduced into our legislative framework, and what will it have the effect that we wish it to have? And perhaps on a personal note, I can say that as a gay man who grew up in the apartheid era, I'm very mindful of the impact, the symbolic impact of laws. So I grew up under the Immorality Act in the apartheid time, which, as you would know, not only criminalized sex and romantic relations between people of different race groups, but it specifically targeted the gay community, and particularly men who have sex with men. And I'm very mindful of the impact of a negative law. And so the inverse of that, I think, is that a positive law can have a very powerful impact, not only on this community, but on the broader society. Thank you very much.
Thank you very much, Pierre Broard, for that presentation. Our members, do we have any questions for clarity? Oops. Okay, Honorable Dodovu.
Yes, thank you very much, Honorable Chair. I understand the presenter to be saying he doesn't have a problem with the current bill. He wants it to be expedited. The main thrust of his submission is that he needs the people in the sector that he mentions to be protected. And if that is the case, he could share with us the extent of and the magnitude of the problem that he's raising. Is it wide, or is it narrow, in a sense that it happens quite frequently to a whole number of people, or it is just a limited problem as he sees it? Thank you, Chair.
Thank you very much, Honorable Dodovu. Yeah, I think I probably had the same concern in terms of your support for the bill or not, and if you were happy, with the definitions, as well as with the exclusions in terms of that bill.
Yes, I think we recognize, I'm not a lawyer, obviously. As I said earlier, I'm a psychologist. So sometimes the legal niceties can be quite obscure. But I recognize that distinguishing between something that is an opinion that is unpleasant versus something that crosses the threshold of inciting harm and hatred is sometimes difficult to discern. And I think our view would be that people are entitled to their personal views. It becomes more problematic when those views are put out on social media platforms, or they occur in spaces where a large number of persons can be on the receiving end of those views, and it might be reasonably assumed that they could, in some instances, take those utterances as some kind of incitement to do harm. And again, I recognize that that's a tricky terrain. But I think, for example, if someone on a social media platform or even in a faith space says, you know, these people are evil and should be exterminated from society, I feel like, you know, that kind of statement would easily, in our view, meet the requirements of hate speech. So we do recognize the exclusions around, I think they were along the lines of being able to make certain scientific or academic pronouncements. Faith spaces were also excluded from the bill, and I think certain media and other sort of spaces. So we recognize that the bill, in a sense, must make allowance for discourse and allow people to have their opinions. It's where it crosses over into hate, I suppose, that we would find it challenging. And obviously, if someone committed a serious crime like rape or assault or murder, in the commission of that, they invoked the person's transgenderness in the commission of that crime, we would like to see that as an exacerbating factor. On the question of data, in fact, this is a challenge in South Africa. We have had a hate crimes working group in the LGBTQ sector for a number of years, and it has been challenged by gathering good data, because as you can imagine, that is not an easy process, partly because many people who experience hate crimes or forms of discrimination don't come forward. And quite often it is because they do not have faith in some of our institutions to bring those cases forward. So we probably have an underreporting. There isn't I would say there isn't a completely scientifically agreed statistic. But again, we would make a case that it isn't necessarily the numbers that we should only be interested in, but the fact that these happen at all is of concern, and therefore we're asking to be recognized in the Act.
Okay, thank you very much, Pierre, for your responses to our questions, as well as for your presentation and for coming to talk to us. Thank you.
Thank you very much for having me.
On members, we've got, I think, 3 more presentations for today. The next one, it's the Scalabrini Center of Cape Town. Mr. James Chapman, I see you are, okay, I don't see you. Mr. James Chapman, yes. Welcome, Mr. Chapman, to this platform. Thank you for your submission that you made to the committee on this bill, as well as accepting to make a presentation to the committee today. We'll be giving you at least 15 minutes to make your presentation. Thereafter, members of the committee will interact with you if they have questions of clarity. Yeah, and if you could please perhaps just focus on, we'd prefer if you could focus on what your issues are with the bill and what your recommendations, if any, are for the bill. Over to you, Mr. Chapman.
Thank you very much. Thank you to everybody for the opportunity to make these oral submissions. May I share my screen?
Do you not have rights yet? Okay.
I think they've just been given. That's. Are you able to see my screen?
Yes, we are. Please continue.
Wonderful. Okay. So as I said, my name is James Chapman. I'm the head of advocacy and legal advisor at the Scalabrini Center of Cape Town. We will likely not exhaust our time, but I would just stick to the sort of pertinent aspects. Just to mention before I do who we are. So Scalabrini Center is a registered NPO that perceives migration as an opportunity and is committed to fostering integration between migrants, asylum seekers, refugees, South Africans. Our mission is to welcome, to protect, to promote and to integrate mobile populations in local society. And in providing assistance to mobile populations, we advocate for respect of human rights and the use of a holistic approach that considers all basic needs. So I'm just going to, there was just that which I covered as by way of introduction. I'm going to talk to what we support and our view with respect to the bill, the areas for improvement, and then just some concluding comments. So when it comes to the bill, so there's been a long history where particularly in the context of the 2008 xenophobic violence, the 2011-2015 xenophobic violence, from around sort of 2009, 2010, there was the hate crimes working group, the Consortium for Refugees and Migrants South Africa, of which the Scalabrini Center is a member of both. I've been really active in trying to push for the bill, and I think that there have been a lot of good and positive developments, and the bill is in a very good state at the moment, and we would endorse and support a passing of the bill, and maybe just tweak one or two minor aspects. The bill is really crucial and important from the perspective of the kind of really severe emotional and psychological impact of repeated xenophobia motivated crimes, attacks, hate speech on vulnerable migrants and associated individuals and group psychosocial trauma. I mean, this is in many cases compounded by the fact that people who are sort of forced migrants, refugees, potential survivors of trafficking, stateless individuals, a lot have experienced very severe trauma prior to coming to the country, and then to thereafter they have sort of re-victimization in the form of xenophobic violence, xenophobic hate speech without adequate recourse. Is problematic, and this bill goes a long way to kind of provide justice and recognition for these kind of instances. We have seen in practice a lot of the time that when crimes occur, the xenophobic aspect or xenophobic nature is either pushed down or set aside or not considered. And I think that the passing of the bill will help to sort of raise it, and not have a kind of disregard for this hate element within crimes. There's also somewhat of a culture of impunity for perpetrators of hate crimes, particularly in the space that we operate in. So the hate speech, hate crimes against vulnerable migrants, refugees, asylum seekers, and there's institutional discrimination that makes it difficult to obtain recourse. Passing the bill will ensure an increased sensitivity and awareness of the duty of the South African police services to protect individuals and their property in instances of xenophobic related crime. And there have been lots of examples. One can look, for example, to the Equality Court case back in 2008, wherein the South African police protected from looting and harm the shops of South Africans, but to the detriment of completely ignoring and not providing anything for the foreign shop owners, and there were enormous losses. And also assaults that took place. So this will help, as I say, with respect to recourse. We believe that the bill will assist with the prosecution of xenophobic hate crimes and hate speech, the hate crime and hate speech, and hate crime and hate speech related crimes, amplify argument and aggravation of sentence and appropriate recourse. It will hopefully assist also with the rehabilitation of sentenced individuals, and allow for the reporting and quantification of such crimes, and allow for adequate prevention programs. We also note that it's in line with a number of policies and international instruments, including the International Convention on the Elimination of All Forms of Racial Discrimination. Obviously, you know, sort of 22 years ago, there was the World Conference Against Racism, Racial Discrimination, Xenophobia, and Related Intolerance in Durban, and there was a follow-up not that long ago of the National Conference to commemorate the 20th anniversary of the Third Conference Against Racism, Racial Discrimination, Xenophobia, Related Intolerance. I mean, at that conference, we even found at that stage that even though it was a World Conference Against Racism, Racial Discrimination, Xenophobia, and other related intolerance, a lot of the signage and everything just talked about the Conference Against Racism, and it almost appeared that as though xenophobia was left off the agenda. And I think that that's a really crucial aspect of the bill, and another, you know, to bring it to the fore and to recognize this vulnerable migrants, refugees, asylum seekers, and the protection that should be afforded by the bill. There's obviously also the National Action Plan to combat racism, racial discrimination, xenophobia, which also supports the passing of the bill. I mean, if we look, you know, it's also not something that, you know, it's historical, you know, 2008 xenophobic attacks, xenophobia, xenophobic speech, xenophobic violence are ongoing and have been for years. And we even see the incident of the fire in Marshalltown quite recently, where on the 31st of August there were concerns raised in political discourse in relation to immigration and xenophobia. You saw in the aftermath of the fire, some certain political leaders pointing to irregular or illegal migration, and to civil society organizations being called as faulted when there was no prior involvement. And in fact, there were even civil society organizations who had pains to try to get intervention before the building got to the state it was in. And this has sparked a lot of discussion. And that, I mean, it's just one example of the kind of the current sort of political climate and tone. And I think that the passing of the bill will go a long way in actually kind of raising that xenophobic violence, xenophobic hate crimes, hate speech cannot continue to take place without repercussions, and should be addressed at the very least in terms of in aggravation in the instance of hate crimes or hate speech. Then in terms of areas for improvement, so one would hope, and you know, it just to raise that, you know, there've been very limited effective prosecutions since to the 2008 xenophobic attacks, the 2011 ones, 2015 ones, and that's exacerbated by the fact that it's not possible to take statements from certain migrants, either those that are completely incapacitated or those that are deceased. And I mean, this point was raised, and I won't labor on it too much, because it's also spoken to by the colleague from the hate crimes working group. But if you look to Section 5 of the bill, there just seems to be a slight sort of maybe oversight in that if somebody is dead, then they're not able to either make a victim impact statement or allow for and provide for somebody else to make one. And so currently a deceased migrant would neither be able to give a statement nor authorize another person to do so on their behalf. And so the Scalabrini Center of Cape Town is submitting, made in our submissions that the prosecutor should be required by Section 5 of the bill to also obtain critical input, either from the group to which the victim belonged, the community from which the victim belonged, or organizations that work directly with the group to which the victim belonged. Additionally, the prosecutor should be required to maybe explain the absence of such a statement in the case of the death of a victim. So those are the kind of the aspects, particularly to section 5, that we thought should be tweaked. Going on in terms of areas for improvement, just to note that section 1 of the definitions grounds, point E and characteristics point A. We wanted to extend our appreciation because we made submissions for the inclusion of asylum seekers, and we see in the most recent iteration of the bill that this has been included. And while this is very positive, one might want to speak to and include the term undocumented people as well. We saw the horrific case of the death of Elvis Nyati at the hands of xenophobic violence in the absence of having a document on him, an identification document on him. We think that being undocumented and that a basis for hate crimes, hate speech is something that should be catered for and provided for as a category. And then also to note that we've seen that many migrants in South Africa, as I said, migrants and South Africans alike, have an additional level of vulnerability to hate crimes and hate speech if they're not in possession of documentation. I mentioned South Africans there, and one might question or not understand, but there are a lot of undocumented South Africans. There are a lot of South Africans who struggle with getting birth registration documents, which then has a ripple effect on getting other documents. You have cases where a South African national is a child of a South African father and a non-South African mother, and in those instances, getting documentation is very difficult. And so, you also covered, those who are at risk of statelessness or stateless people in talking to this sort of possession of documentation, not being in possession of documentation. So just to raise that that is another area that should be included. And then just to conclude that, with the caveat of adding in relation to undocumented persons as a characteristic, and then and ground, and then also the with respect to the victim impact statements proviso, we would move for the adoption and fully support, motivate for the passing of the bill, which has been, as I say, years in the making, and would play a crucial role for the reasons discussed above. Thank you.
Thank you very much, Mr. Chapman, for the presentation and bringing forward the issues that you raised. Honourable members, are there any questions for clarity? Honourable Badenhorst.
Mr. Chapman, good day. Thank you so much for your input and your presentation, and the work that you are doing in your field. I think it's very, very necessary. Mr. Chapman, so as legislators, we, and this has been mentioned before today, I don't know what time of the day you joined our presentation, but as legislators, it's our responsibility to try and get the best possible legislation out there. Legislation that's practical and that'll work. This bill wishes to, and I refer to one of your comments you made in one of your slides with regards to disregard for the hate element in the crime. This bill wishes to criminalize hate speech, but if you look at the definitions, and I've said this before, it defines harm, but it fails to define hate or hatred. And some of our presenters today has also said that maybe it's because it's not possible to define hatred, much as it's not possible to define love. So I would want to ask you what your views are on whether this is indeed a critical element of this bill, to be able to find a definition for hatred as a crucial element to the bill. And then secondly, just your views, if you don't mind, on the maximum penalty of 8 years for a first offence. What do you think? What is your views about that? Thank you so much. Appreciate it.
Thank you very much, Honorable Badenhorst. I think, Mr. Chapman, those would be the two questions for you.
Right. So thank you for those questions. So, I mean, I think a couple of the previous speakers have also spoken to. It might well fall upon and be best suited for the courts to kind of canvass and cover what is covered by hate. And I think that the absence of a definition shouldn't be a stumbling block. It shouldn't be a point on which the proceeding kind of falls or rests. There are things that sort of obviously would constitute hate or hatred. So where somebody is assaulted for the on the basis of their ethnicity, their nationality, where there's speech that is so harmful, that it goes to the very core of, and it's on the basis of something that is an immutable characteristic, something about an individual that they can't change about themselves. Then I think that that would be captivated and covered by hate. But I do think that the courts are well positioned to kind of flesh this out through jurisprudence. When it comes to the maximum penalty of 8 years, I mean, I did speak to the fact that there is kind of scope for rehabilitation, and I don't think that the penal system maybe is as effective as it would sort of purports to be. I think that there are other like really crucial aspects kind of that need to be taken into account, and there must be an opportunity for reform. And so I would not to rest too heavily on the limitations. So I don't have or we don't have a particular gripe or misgiving in terms of the maximum penalty of 8 years. Okay, thank you.
Thank you very much, Mr. Chapman, for your responses to the questions from members, and thank you for your inputs into this bill.
Yeah.
Our members, we'll move on to the next presentation. I think Honorable Cuthbert is on the platform from the Democratic Alliance. Welcome, Honorable Cuthbert, to the platform. And thank you for your input into this process and for accepting to make a presentation to the committee. We'll be giving you 15 minutes to make your presentation. Thereafter, members will ask you questions for clarity. We would prefer that you actually home in on what your issues are with the bill and what your recommendations are. Over to yourself, Mr. Honorable Cuthbert.
Thank you very much, Honourable Chairperson, and certainly will hone in on the specificities of this. Thank you to the committee for the opportunity, and I look forward to taking you through our submission this evening. I'm just going to turn off my video for bandwidth purposes. So possibly to start off, it cannot be denied that crimes motivated or exacerbated by hate do not occur in South Africa. I think we're all well aware of that fact. And the DA condemns in the strongest terms hate speech and crimes motivated by hatred based on the immutable characteristics of a person. We also agree that perpetrators of crimes motivated by hate should be held to account for their crimes. However, we don't believe that it's necessary to create a new special class of hate crime when hate can instead be used as an aggravating factor at the sentencing stage. The DA further acknowledges the prevalence of hate speech within society, which we do believe should be condemned with the strongest terms. However, we do believe that the harsh prison penalties attached to the crime is a mechanism that is not necessarily going to be that effective in combating the problem. There are existing remedies within common and civil law, and we also believe that you need to address the root cause of the issue in order to be able to deal with this specific type of crime. More specifically, regarding the various issues we have with the bill in its current format, this regards the fact that there is a definition of harm which we feel is both vague and broad. And we are of the view that in order to create a clear law, this definition must be improved in order to provide greater certainty as to what will constitute a harm. Some of the categories included within the definition of harm we feel are inherently subjective and would be difficult, if not impossible, to objectively determine. And we feel that this may leave the door open to criminalizing offense. We are of the view that a reasonable person standard should be included within this specific definition. And we also are quite concerned by the fact that the concept of hate is not defined within the bill. And if the core concept around which this particular bill focuses is hate, this needs to be included within the bill, and a clear standardized definition needs to in fact be provided under clause 1. Then some of the more general issues and risks that we perceive by virtue of passing this particular piece of legislation. And that is the creation of a new crime of hate speech with harsh prison penalties attached. We feel that this may increase self-regulation of speech. And we think that this is a natural occurrence by virtue of the penalties that would be associated. And we feel that this would impinge on freedom of speech. We need to understand that there's a marketplace of ideas, if you look at the work of Mill, and we need to be able to freely exchange these ideas, confirm these ideas, reject these ideas within this marketplace that exists. And if we do not have the ability to be able to do so, then we feel as if this would have a chilling effect on the freedom of expression and freedom of speech. If you just look at journalists and citizens in particular, they may not necessarily take the same angles that they do to arguments or stories in the case of journalists, because they'll feel as if they may fall foul of the provisions of the bill. And even if they've not done anything that would constitute a hate crime or hate speech, it may lead to the dilution of the kind of content that we receive in the media. The other thing is we have a voluntary exchange of these ideas between the media, politicians, citizens, and we feel as if this would impinge and impact on our democracy if we stifled this kind of debate. Ultimately, we need to make sure that we instill greater levels of tolerance in society amongst the population. And as said earlier, we need to be able to interrogate the views that people put forward. We need to be able to consider them. And if there are valid views, in the case of people using their freedom of expression, then there is space for them to be reaffirmed. In terms of the grounds and the characteristics contained within the bill, and I'd like to go into a little bit more detail here, we believe that there needs to be a clear justification for the inclusion of all characteristics, and this should be provided by the department. While we don't discount the fact that these characteristics contained in the bill are not currently subject to hate crimes, the inclusion of these characteristics must be supported by clear empirical evidence that justify the need for protection in criminal law. And a couple of the other presentations have spoken to the quantification of these problems. And I think it's important when creating law to be able to have all the necessary evidence so that we can make an evidence-based decision. We also believe that the presented justifications and the grounds are not necessarily supported by the department itself, because they have not been able to supply the committee, both at NA level as well as at a NCOP level, with the necessary information to be able to back that up. Ultimately, what this will fall foul of, we believe, is of Section 16(1) of the Constitution. And this entails everyone has the right to freedom of expression, which includes freedom of the press and other media, and freedom to receive or impart information or ideas. However, under Section 16(2), the right does not apply to propaganda for war, incitement to imminent violence, or advocacy of hatred that is based on race, ethnicity, gender, or religion, and that constitutes incitement to harm. The Constitution, therefore, excludes the ambit of freedom of expression, the advocacy of hatred based on one of the 4 listed grounds, as said, race, ethnicity, gender, and religion. And this is a closed list, and I think it's an important concept to share with the committee. And it's deliberately different from Section 9 of the Constitution, which bars unfair racial discrimination, not only on these 4 grounds, but also on 13 others. Therefore, we need to recognize the grounds in Section 16(2) of the Constitution are limited to 4, and it's not an oversight and cannot be ignored. This closed list seeks to keep constraints on the freedom of expression to an as limited list of categories as possible. Therefore, we hold the view that this particular bill expands the ground significantly beyond these 4 constitutional categories, and this will require grounds which limit protected speech to pass the criteria laid out in Section 36, which is the rights limitations provision of the Constitution. Therefore, we believe that under Section 36(1)(c), which states that the nature or extent of the limitation may be taken into consideration, the restriction of freedom of expression beyond that which is already permitted in Section 16(2) of the Constitution and the criminalization of such conduct is a significant rights limitation and places the constitutionality of the hate speech provisions of the bill in serious question. Furthermore, any limitation on freedom of expression on grounds not already included within the Constitution must, during a Section 36 rights limitation analysis, give consideration to less restrictive means to achieve the purpose of curbing hate speech and hate crimes. This is Section 36(1)(e). These less restrictive means already do exist, and this has been put forward in our submission, and this is with regards to PEPUDA and the common law. Finally, as the grounds extend beyond that of what is included currently in the constitutional provision of 16(2), as exceptions to the Section 16 right to freedom of expression, clear justification should be provided as to their inclusion within the bill prior to it being enacted. It's not good enough to fix the problem after the fact. It needs to be addressed up front. If we do not do so, we hold the view that this would be irresponsible on the part of the legislature and essentially amounts to kicking the can down the road, as these arguments would then be challenged by the courts and need to be made and will inevitably be challenged on constitutional grounds in any case. We also hold the view that there's a lack of justification for the bill in its entirety. And this results from the fact that we believe that the existing remedies within this particular ambit, like we've mentioned earlier, PEPUDA, provide enough of a basis on which to be able to prosecute these particular types of crimes. And we feel as if there's an instance of double legislating for hate crimes here. And we argue that hatred should rather serve as an aggravating factor during the sentencing stage. And we believe that this should be seriously considered by the committee in its deliberations and in the final drafting of the bill. And ultimately, we need to look at what it is that the sanctions are that are contained within this particular bill. And this is the criminalization of hate crimes and hate speech. And we once again feel that it doesn't root out the negative social attitudes that citizens of the country may have. It doesn't begin to address the fact that people hold prejudices and hold discriminatory views towards one another. And I think there needs to be a greater emphasis on rehabilitation mechanisms as opposed to imprisoning people and fines. And this proves true in many other, criminal instances where there are harsh penalties that are put in place, and that doesn't necessarily lead to a decrease in recidivism. And I think it's important that we address the root cause of the issue and the social attitudes that have been developed due to our, painful past. Ultimately, we believe that rehabilitative measures should be included within all penalties or orders so that we can address these core prejudices and motivations which underlie these hate crimes as well as these instances of hate speech. And we believe that this will reduce recidivism by making sure that we have these rehabilitative measures in place. Because ultimately you will end up in a situation where even if people are prosecuted, they will still not change their attitudes or the views that they hold. And that's ultimately detrimental to society. And we are also of the view that the 8-year jail term is overly harsh. We think it's unreasonable and we think that it's disproportionate. And the thing is that the risk of being imprisoned under such a lengthy or for such a lengthy period of time, we believe would deter people from expressing anything which may potentially result in a criminal sanction, thereby once again stifling robust debate on matters that may be deemed to be contentious. Ultimately, we acknowledge that the objectives of the bill are laudable, given the history of South Africa and the lingering effects that this history has on our society in present day. And I think that goes without question. And I think that all the members of the committee can acknowledge that we do still live very much with the effects of both the apartheid regime and colonialism prior to that. However, we do believe that this particular bill is fatally flawed and should ideally be abandoned in favor of hatred being used as an aggravating factor in the sentencing of existing crimes and the utilization of existing laws to combat hate speech. We think that the hate speech provisions will have a chilling effect on freedom of expression and the exchange of ideas in society, as I earlier mentioned, and ultimately societal policies which aim to rehabilitate and educate people are preferable to crude criminalization, which addresses only the symptoms rather than the cause of the crimes motivated by hatred. That is the submission that we have made on behalf of the DA, which has been supplemented by our written submission. And I'll hand back to you, Chairperson, for any questions that may be asked.
Thank you very much, Honourable Cuthbert, for the presentation. Our members, are there any questions? We have Honourable Dodovo.
Yes, thank you very much, Honourable Chair, and thank you very much for the submission. Just 3 issues emanating from the presentation. Firstly, in terms of the DA's submission, the 8-year sentence is harsh. Does it has an alternative or a proposal in terms of, other than what it says in terms of dealing with the hate speech, that if 8-year maximum sentence is harsh, do they have an alternative in respect of that? Secondly, Honourable Chair, the DA is critical of the definition of hate, harsh, and the victim, and it does explain its proposals for the definition of harm and the definition of hate, and it doesn't say anything in respect of the victim. And in this instance, my question would be, do they mean the juristic person in that respect or not? Yes, those 2 are okay, Honourable Chair. Thank you.
Thank you very much, Honourable Dodovo. I was wondering if Honourable Mikolakis was going to ask a question, but anyway, maybe just one from my side. Just in terms of the Constitutional Court judgment on the Xolani matter, in terms of the exceptions of freedom of expression, in addition to the 4 grounds, obviously, what came out of that judgment is the issue of sexual orientation. Now, similarly, there are the grounds that are identified in the bill. Obviously, if they pass the Section 36 test, that should be a consideration. Maybe just your view on that one. I think those are just the questions from us. Over to yourself, Honourable Cuthbert.
Honourable Chair, I beg your indulgence.
Sure.
I'll just give the 3rd one.
Yes.
If you allow me, can I just quickly ask the 3rd question? Some of the presenters who appeared before us were saying that this bill in its current form will not pass the constitutional muster on the basis of the fact that it infringes on Section 36 of the Constitution that deals with the limitations of the rights. And I see that the DA also expresses the view. Does it think that the bill in its current form infringes or impugns on the limitations of rights in terms of Section 36 of the Constitution? Thank you, Chair.
Thank you very much, Honorable Dodovo. Over to yourself, Honorable Cuthbert.
Thank you very much, Honorable Chairperson, and thank you to yourself and Honorable Dodovo for the questions. I think the first one is expanded upon in the presentation regarding the harsh sentencing. So you would understand that we disagree with the lack of justification for the bill in the first instance, and we believe that you need rehabilitative programs and re-education programs to try and address the root cause. So a question of penalizing people with jail time is not a consideration for us as the Democratic Alliance at this stage, and we would look at a more restorative justice approach as opposed to trying to penalize people for actions that are contained within the bill itself. Then I wasn't too clear on the second question that Honorable Dodovo had asked, because it seemed as two questions that were sort of combined. If I may just ask for clarity on that, Chair, if you could maybe just repeat.
He said in your presentation, you define or you look at the issue of hate and harm, but you do not look at the issue of victim.
Sure.
Honorable Dodovo, I'm just summarizing, sorry.
Yes, the victim, yes.
Sure, 100%. So thank you very much for that. I think that's well explained in existing jurisprudence, and it's clear what a victim is. That would be the person who the crime has been perpetrated against, and I believe that that is well established in the law itself. However, I do believe in the case of hate, it's specific in terms of how we attribute the action of one person to another that constitutes hate, and what kind of factors are included in it. I think it's important, considering that this is a bill that deals with hate speech as well as hate crimes, to be able to define that, so we better understand how the perpetrator would then be infringing on the rights of the victim. So I hope that that covers that particular question. And then possibly just to combine both of these Section 36 questions, we do hold the view that if this went to the Constitutional Court, considering the limited use of the limitations of rights analysis in Section 36, that the Constitutional Court, by virtue of them being very confined towards Section 16, and this being an exceptional circumstance, that on those grounds it may be unconstitutional. And therefore we have a concern about what this bill would entail for freedom of expression and expanding those grounds beyond the four that I mentioned earlier, which is race, ethnicity, gender, and so on. I hope that that answers all of the questions sufficiently. If there's any further detail that is requested, we're happy to provide that in writing to yourself, Chair, as well as the committee.
I think that will do. Thank you very much, Honorable Cuthbert, and thank you to you and your organization for making an input into this bill, and for taking this opportunity that we've given you to come and present to us. Thank you very much.
Thank you kindly. Have a good evening, everyone.
Sure, thanks. Our members, I think we have just one more presenter left. Gershwin, if I'm not mistaken, it's Dr. Wallace. I'm not sure if he's on the platform, Gershwin, or you've managed to get hold of him. I know he's scheduled for 1800 hours, but he did indicate to us that he'll join from, Gershwin, is it 17:30?
He's online, Chairperson.
Oh, is he online? Okay.
Yes, hello.
It's Dr. Wallace. Dr. Wallace.
Yes, yes, I'm a female. No, not at all. It happens often. Not at all.
Apologies. I don't know why we assume things sometimes. I guess
No,
it's wrong.
it happens to be very frequently.
But anyway, let me just take this opportunity to welcome you and thank you for making your input into the bill, as well as making this presentation to us as a committee. We'll give you 15 minutes to make that presentation. Thereafter, members of the committee, if they have any questions for clarity, they would ask it. And I'm requesting that if you could perhaps home in on the bill in terms of what your issues are and what your recommendations may be. Over to yourself, Dr. Dale Wallace.
Thank you, and I thank the committee very much for the invitation to speak. I do appreciate it. I said in my written submission that mine might have been an unusual submission in relation to the others. I'm not a lawyer. I have to say at the outset that I'm not a theologian. I've been in religion studies for 30 years, and I've worked, researched, and taught among all religions in South Africa. And I have been researching in the past 4 or 5 years, particularly on a fundamentalist Christian movement that has a very strong socio-political agenda in South Africa. It is global, undoubtedly. Its genesis is in the United States, and there's sufficient evidence to show that $270 million has been sent to Africa to influence laws and policies. Now, this movement is within evangelical charismatic Christianity. And I know this will get to the hate speech bill, and I said from the outset, I have to just give some background information. Why I say it is socio-political, I have to mention something that drives the movement, called the Seven Mountains Mandate. And this mandate is identifying 7 sectors of society that have to be influenced in order to transform society according to God's will. So it is a strongly socio-political because it's really hit at every sphere. These sectors of society are government, laws and policies, business, family, health, education, basically all spheres of public life. Now, in South Africa, this sector is a network of individuals, churches, and organizations. And whilst each one of them might have their own particular agenda, they are united in the goals of influencing laws and policies and society, according to what they say is God's mandate. The primary figures, the most visible in this movement in South Africa, are Freedom of Religion South Africa, 4SA, who are the legal advocacy of the movement. And also, importantly, and I'm mentioning few out of many, Dr. Arno van Niekerk. He might be known to Parliament because in 2019, he presented his 10-point plan to all parliamentary parties ahead of the election. And in that 10-point plan, he said that there should be no laws that contradict God, and that the liberal agenda must be uprooted wherever we find it. And it is that statement really that is the driving force behind the movement. In 2019, all this pre-COVID, I also attended an influencers conference in Paarl. And Nadine Badenhorst, who was the advocate for SA, as well as Dr. Arno van Niekerk, were the keynote speakers. And the goal of the conference was to locate individuals and situate them in all sectors of society in order to exert their influence. At this conference, Nadine Badenhorst said, and I was in attendance, she said, it is not enough just to win in the courts. We have to change the culture. So it's quite substantial, and it has come a long way in the past number of years. Now, with regards, and I apologize, I'm not a lawyer, so I can't speak to many of the issues that other participants and speakers have. But I've looked very closely at the hate speech bill and at the links between hate speech and hate crimes. I've also looked at the issue and the questioning of the categories of harm and categories. And I'm going with apologies to paraphrase Deputy Minister John Jeffrey, who said that the current laws have proved ineffective in stemming a number of crimes that are motivated by hate. Now, in my position and in the research that I've done and am currently still engaged in, hate, and I listened to the previous speaker, hate is a difficult word to define, because from where I'm coming from, I don't know that hate is applicable, but there are crimes and they are motivated by a particular fundamentalist religious agenda, which makes it different because, and I used fundamentalist quite intentionally, and I can justify that. But what they're saying is God's will can't be questioned. So if God says homosexuality is an abomination, then that is what they have to follow through on. So that's a complexity. But what I can do is now, from the perspective of this religious agenda, what I can do, and I'd like to, is just to give some brief examples of how real negative outcomes and how hate crimes, or let's call them religiously motivated crimes as an outcome, are inspired. In May this year, Pastor Roya Strauss said on his Facebook channel that nobody is born homosexual. He said there are demonic forces involved. Now, he has 85,000 Facebook followers, and if only a third of those forwarding. So the spread of message and the people coming back, we have a global audience that are interacting all the time. I've selected to talk very briefly about the healthcare industry, because here we've seen a real impact, and it's been heartbreaking, and I've had my own personal involvement. In last year, the MEC for Health in KwaZulu-Natal, Ms. Nomagugu Simelane, she marched with the LGBT community in Vryheid in a pride parade. And this pride parade was large, and she spoke very clearly afterwards, saying that she was marching with them in solidarity to prevent this rising tide of homophobia in the healthcare industry and the resultant neglect and harm exerted to patients. And I had my own brush-in with a young black man. I know the family. He's a young gay black man who was set alight in his sleep. He was badly burned. He was moved between hospitals and not to a burn unit. The setting, this arson, was really as a result of his sexual orientation. And the nurses in the hospital were not cleaning his bandages, not changing his bandages, not washing him, not feeding him. This was left to his mother. Once I intervened and I interviewed nurses, as well as from the Vryheid section, as well as from my own encounter, the nurses said that they've been told by their churches and on these various social media platforms that homosexuality is an abomination, so they can't attend to these people. Now, Arno van Niekerk recently did an interview with Zandile Vilakazi, and I must say at this point, I endorse and respect everybody's right to their opinion, and I will get to freedom of speech and expression in a moment. But in this interview, Ms. Vilakazi unequivocally says that Parliament are just legalizing and legislating abominations. She said they are legalizing and legislating everything that is a sin to God. Now, that is not correct, because there are many of God's laws that are not mentioned. There's a primary, really, sexual agenda to this and to sexual orientation. Many laws are quite silenced. Ms. Vilakazi also says openly on this interview that was recent, she said homosexuality is an abomination and we have to overturn it. And she also gave a dig at Parliament to say that we currently are being ruled by the ungodly. Now, again, all of that within their rights and their freedoms. These kind of issues by this movement are spoken of as battles. Spiritual warfare is also very part of the theology. So they are fighting against enemies or the demon or the devil, as Pastor Strauss committed it. In order to realize this agenda that they say is motivated by God's wishes, they see that there are many new apostles and prophets, that the apostolic age is not over, and that God has spoken to them directly to inspire the battles that they undertake. Obviously, the hate speech bill and the Papuda Amendment bill are seen primarily as the greatest danger to what they see as their religious freedom, because they need speech. They need to be able to articulate their views and disseminate their views. I was concerned by the requests for exemptions, because in my field, we problematize something by standing back and trying to bracket our own. We all have beliefs and prejudices in politics, but I try to stand back, we bracket that, and we look at a statement and think, who is saying that? Why are they saying it? Who is included? Who is excluded? Who wins? Who loses? And in doing that, the exemptions that are fought for on the grounds of religious speech, when they're articulating into, as I try to show in the healthcare sector, it is really a really difficult problem to address, and I've no idea how the courts would address that on the counts of religious freedom. My example of the healthcare system can be mirrored in the school. We've had many academics in South Africa for many years, Barros and MCB, who've done amazing work at the plight of LGBTQ pupils in our schools. It's not only bullying, victimization, there's been beatings, and the murder rate in this country has been escalating. So when we talk about objections to categories of harm, whether they be psychological, social, emotional, economic, it's very hard to separate those because they all collide. In my healthcare example, in the school example, there's physical abuse, there's emotional abuse. So I understand when I know Forisay have said that social and emotional are subjective terms. They are subjective, they're not defined. But if they stepped out, I could take them and show them what social and emotional harm really are and how they're impacting in the community. Now, Arno Verniekerk, very lately, his project now is called Time to Rise SA. And in his Time to Rise program, he's called on all Christian churches in South Africa to unite behind them in realizing what is God's will for this country, for Africa, and for the world. And this was the other point I made in my submission, that while objections must be respected, that this is not taken to be the Christian position, because there has been no support given outside of that sector by vast swaths of the Christian community, not the South African Council of Churches, the Desmond Tutu Foundation, my colleagues in theology, who are church leaders themselves, are vehemently opposed to this agenda. And they also are absolutely opposed to any discriminatory rhetoric. And what I'm saying is that prejudice and discriminatory rhetoric has negative outcomes. Our country has come from such a divisive past, and we are a religiously plural and diverse country. I don't believe that religious freedom, as we understand it, is under threat from minority to majority religions. But this cannot be seen as a Christian position. I know that Freedom of Religion South Africa, Michael Swain, has often said that there's no hierarchy of rights. I'm not a lawyer, but in reading the Constitution over many cases to try and understand more, we have Section 9 of the Bill of Rights, which are non-derogable rights. These are rights that cannot be overturned under any circumstances at all, even in the case of war. So that is absolutely unambiguous. And the first of these are equality and human dignity. There's also the right to safety. Now, when I see in actual research and in real lived experiences that equality is being breached, because equality, it's unambiguous. It's in all circumstances, in business, in schools, in healthcare, in what we do. So I would say that any laws or amendments to our legislation that can possibly prevent what we have witnessed and are witnessing in many sectors. There are many things we can present on a piece of paper, but in lived experience and reality, the harm is very disturbing. So again, my apologies. I'll stop there because my presentation, I know, is different. But I was asked to just give a short presentation here. So whether it's a hate crime or how difficult a court could deal with something that a community says is mandated by God, I don't know. But it is having extreme influence in our country. So I thank you.
Thank you very much, Dr. Dale Wallace, for imparting some of those ideas and thoughts with us. Our members, do you have any question for clarity?
Thank you, Chair. Thank you very much for the opportunity, and thank you, Dr. Wallace, for your input. It's much appreciated. I know it's late in the day, so I'm not going to belabor my point too much. We all know that hate speech and hate crimes cannot go unpunished. I mean, that's a given, and I think we all agree on that fact. However, do you not think that our existing law make ample provision for the successful prosecution of such crimes, as we've seen recently in the Sparrow case, etc., etc.? There's the criminal on the criminal side, there's criminal injuria, and obviously on the civil side is Pepuda. Should we not then rather look and what is your feelings about it? That we shouldn't we rather look as a society at other means of sanctions, for example, restorative justice? And what is your feelings about restorative justice? I'd love to get your input on that. Thank you very much, Doctor. Appreciate it.
Thank you very much, Honorable Badenhorst. I'll just add one more question. Perhaps you could speak to this matter as well. I think you made quite a profound comment in that you don't think that religious freedom is under threat, especially in this country, given our current constitutional framework. But also, I think it's quite interesting because some other comments that do come through with regard to hate speech, and people try to say it's almost similar to what happened during apartheid, where people were not allowed to speak out on certain matters. But obviously, I think given our constitutional framework, obviously we are nothing like what was there in the past. But anyway, a comment from you on that. Over to you, Dr. Wallace?
Thank you both for the questions. And I have really given a great deal of time to thinking on both of them, because I have long been an advocate of religious freedom, freedom of expression, freedom of speech. Part of the research I've done that has impacted on me as a human being and as a citizen, I sometimes just go for a long walk and it's painful. So where we have non-discrimination and protections against non-discrimination on various categories, race, religion, gender, sexual orientation, disabilities, you know them all. Are there sufficient laws? And what I have just seen over the years, and I could give so many examples, or in the healthcare system, how does one possibly penalize people sharing information on social media and being able to track the impact of that speech? In my book, Zandile Vilakazi was guilty of hate speech, because at the other side of it, I can see certainly what has impacted on human lives, and it's very broad. Race, like the case of Penny Sparrow, race has been addressed much more swiftly and much quicker. We still live in a country where we have a lag from apartheid. We can't put our heads in the sand and say that values and attitudes and prejudices were changed by our change in 1994, because they are latent. They went to bed under our rainbow years, but they have certainly resurfaced. I haven't seen yet laws, and that's where I go with Deputy Minister Jeffrey, of saying that these laws have just proved ineffective. But I'm saying, and I don't have the answer to it, is the complexity when a sector within a majority religion, a sector, is talking about God told me, and we are mandated by God. So how on earth that would ever be addressed, I don't know. And I don't know if I'm even answering the question correctly. But I haven't seen yet any response like we've seen to cases of discrimination on race, on disability. I've seen a much quicker address. Sexual orientation and gender issues have been much more tardy. And may I just ask you the last question you asked me? Could you just repeat it?
I was just making reference to what you said around the fact that religion as a freedom is not under threat in South Africa. The point I was making is that even if you legislate on hate speech, given our current constitution and freedoms that we have as a country, it's not similar to what was in existence during apartheid, because there's some views that you start putting in laws around hate speech, you would actually be doing similar kind of things that was done under apartheid. But yeah, I was just looking at the two issues, and I thought you could comment on that.
Yes, definitely. There's this very difficult balance of how to balance and not to be retrogressive, because we had a constitution that provided protections against non-discrimination, protection against non-discrimination on multiple levels. We have rights. We came from a system, and I'm white enough and old enough to remember growing up in the apartheid years, where we again had these restrictions, and parties were marginalized, racial groups were marginalized, and it's everything in moving forward that we don't regress to a step like that. So yes, a bill that would limit hate speech, we are limiting what we are doing in effect by limiting hate speech is retrogressive. It would go against certain rights of the Constitution. But, and I think there has to be a but, we can't balance the freedom of speech or the freedom of expression against what is really a non-derogable right to equality when real harm is being committed. So I would be the last one to be retrogressive. And also, and it's beyond the time we have here, but anybody is welcome to investigate it themselves afterwards. There has been so much work, and even a conference, religious freedom. I'm not talking about the rights of Christians, Muslims, Hindus, the Baha'i, Scientologists, Rastafarians in South Africa. But religious freedom has been weaponized globally. And there's even been a conference recently. So even freedom of speech is being part of this, is weaponized, and a lot refer to it as just the freedom to discriminate. As I say, this is a complex agenda. It's socio-political, but it is definitely causing impacts in our society, in every sector. So do we leave it alone? Can Pastor Strauss and Vilakazi say what they say and talk about a community, a protected community from discrimination, and say homosexuality is an abomination? I'd love maybe you to give your pitch. Do we leave it at that when real harm and real crimes are being committed?
Dr. Wallace, let me thank you very much at this point for your responses to our questions and for making the presentation that you made. Thank you. Honourable members, I think we are now done with the very last presentation of today. Let me thank you for seeing this process through for the day. Just to remind you that tomorrow we will be convening at 2 o'clock. While you have received the schedule, the one organization that had problems with the network yesterday, Lita Labantu, they confirmed that they will come tomorrow. So just note that they're going to be the last presenter tomorrow. So please, yeah, the reason I'm raising it with you so that you can just relook at the schedule and just note that Gershon will send you a revised schedule today. But thank you very much, honorable members, and let me also thank whoever's on the platform that have made comments on the bill. And I've thanked you after each presentation, but thank you for still remaining on the platform. And let me also thank the legal teams from both the department as well as Parliament, and obviously all of our support officials, Gershwin and Thea, who are also on the platform. Thank you very much all. And tomorrow, I think, will be the last leg of this process. So we'll meet tomorrow at 2. Unfortunately, we couldn't meet earlier because the Multi-Party Women's Caucus is meeting in the morning. Thank you very much, colleagues. See you tomorrow at 2.
Thank you, Jay.